All right. Mr. President, the witness is ready in the waiting room. I will go off camera and wait to hear from you when to bring him in.
Yes. Have we any housekeeping to deal with before the witness returns?
No, Your Honor, not for claimants.
No.
No, nothing from the respondent.
Very well, then please invite the witness back.
Okay, bringing him in now. Mr. Imena, can you hear me?
Yes, I can hear you.
Excellent. Okay, Mr. President.
Thank you.
Maybe bring up the first witness statement of Mr. Amena and go to paragraph 12, please. Mr. Amena, do you recognize that this paragraph is addressing the NRD November 2010 application and some of your criticisms of that application?
Yes.
Focusing your attention on the criticism that begins here of the exploration of reserves. Do you see that you're talking about that there? And now if I could ask to go on to paragraph 13. You say here, in order to meet the requirements of the contract, I would have expected NRD to have collected thousands of samples for this given area. And you go on with further criticisms. You'll agree that you weren't, your position with the with Minarena excuse me, I started the question incorrectly. I need to restate it. You'll agree that you were not working with Minarena when this contract was first entered by the parties, correct?
Correct.
So you'll agree when you're talking here about your expectations, what you're talking about is someone coming after the fact and saying how you would interpret it yourself, not as the party that actually negotiated it, but how you want it interpreted now, correct?
No, I don't agree.
Okay. You will agree, though, sir, you've never found anywhere in the NRD file any communication from anyone at Minarena to NRD stating this expectation as to what the contract requires in order to meet exploration of reserves requirement, correct?
Not correct. In 2009, if I remember well, the then Minister Bazivamo Christophe wrote to NRD explaining that the ministry was not satisfied with the amount of work conducted by NRD. And that was in 2009. So my statement here that I expected them to conduct extensive sampling is based on best industry standard. You cannot conduct proper exploration by only collecting 100 and few samples in an area of more than 30,000 hectares.
So the 2009 letter you referred to was 3 years after the contract was entered, correct?
You're right. And that's at that time, the minister was reminding NRD that they just have a short of time remaining before the end of their contract. And he was telling them that, look, you didn't perform.
If we could bring up C17. And down the bottom, there's rights and obligations of the parties. We could highlight that Article 2 all the way to the bottom. In fact, the actual contract signed by the parties doesn't talk about a level of establishing reserves. The actual contractual language is make geographical demarcation of the perimeters.
That is just one.
Sir, let me finish the question. That's the contract provision you say gives rise to the expectation you set out in paragraph 13 of your witness statement, correct?
Not correct. This obligation, you are just showing me one point, but
Let's
there
go
are
on to-
other obligations.
Let's go on to the next page. Sir, items 2, 3, 4, and 5 do not talk about establishing the level of reserves to the detail you talk about in paragraph 13 of your witness statement, correct?
Not correct. If you look at point number 5, they say that they should provide an evaluation reports of reserves and a feasibility study after 4 years. So to conduct evaluation reports of reserves, you conduct extensive geological, geophysical, geochemical work. You conduct sampling, you conduct drilling, you conduct geotechnical studies, you conduct financial studies. It's a whole bunch of studies that will lead you to reserves calculations and feasibility study. And for that, you cannot just collect 100 and a few samples and think that you will get there. And
Sir,
in fact, sorry.
Sir, if Minarena wanted to impose all the requirements you just listed, it could have set them out in the contract and asked NRD if it would agree to them in 2006, but it did not do so, correct?
Not correct. If you are a miner or if you are a geologist and someone tells you, go and do evaluation of reserves, you understand that you will do that. It is a technical term that encompasses all those studies.
If we could bring up C35, please. C35 is the 2010 application. Do you see that, sir? Now, if you
I
could go
see
to
it.
pages, 101 and 102.
Screen, we know everything, I believe, but how do I blow this up?
And to the tribunal, just so that you're aware that you're not on mute. I don't know if you expect to be or don't, but I thought I would point that out.
Sorry, I couldn't hear.
101 and 102. There's actually an analysis of wolframite in this application, which leads to an estimate of reserves, correct?
This is an estimate of just one deposit, and these are the scree deposit. It means these are the remainings of old activities. And if I may remind you, they were given 5 concessions and they only conducted estimation of tailings resources in only one deposit, which is less than 20%.
That it contains an estimate of reserves of wolframite? Can you agree?
I can agree, but
Okay.
if I can add, this is just for one concession, and it's not even the primary resources. These are the tailings, the remainings.
If one were to read your witness statement, one would come away with the belief that NRD never reached any estimate of any reserve. Isn't that correct?
It's not correct. I clarified in my reports and in my statement that they did good preliminary works, but they didn't do expected extensive works.
If we could blow up on page 102, the reference to scree samples, I'm going to pull it up myself and direct. .2. as you pointed out, this section is only referring to one concession area, correct?
You're right.
And it's only referring to one portion of that concession area, correct?
You're right.
And it says just in that area, there were 130 samples taken, correct?
You're right.
Now you say the entire application shows that only 115 samples from all 5 were taken. That simply wasn't true, was it?
It's true. My assertion is true. I don't exactly remember the page where they state that they only collected 100 and a few samples. And
So
in
you-
fact, the fact that they conducted a non-exhaustive study led them to install a plant that never gone operational. The plant failed to be operational because they failed to conduct appropriate studies before installing that plant. And the government wanted them to conduct proper studies so that they can install adapted plants to these resources.
Sir, you do know that in this application, they explained not that they missed wolframite where they built the plant, but that they built the plant in an area where the secondary reserves of wolframite were not sufficient, but needed to be run off before they reached the primary reserves of wolframite, which would then feed the plant over time. You know that they reported that to Minarena, correct?
Actually, sir, you are confirming what I'm saying. If they had conducted proper studies, they would have never installed that type of plant there. But they failed to conduct proper studies and then installed a dummy plant.
They reached the opposite conclusion that over time, the primary reserves were so sufficient so that when they reached them, the plant would be very productive. And that's why they invested their money in that plant in that location. They told you that in this report, correct?
Not at all, sir. That plant was designed to process scree material, not primary wolframite material.
You do understand that the people who wrote this report and invested in the plant knew better than you what they intended to do and how they intended to feed the plant. You will agree with that, correct?
I hoped they knew better than all of us, but unfortunately, I was sad to see that their plant didn't work. So that is a disappointment that I still feel. We thought they were very good, but in the end, we were disappointed.
And rather than report what was actually said in the application about the timing and what it would take to reach the primary reserves that the plant was built to serve, you reported a conclusion that the plant was built where there would never be any reserves. That was contrary to what NRD was saying its intentions and expectations were, correct?
Can you repeat, please? I didn't get your suggestion.
Your witness statement, rather than report what NRD actually said its expectations were long-term in terms of the supply of wolframite from the primary reserves, simply reported that there was never going to be any to support the plant and was all a mistake. That's how you described the application, correct?
I described the application as a very preliminary work. And in fact, in this 5.2 paragraph that you are showing me, you see yourself at line number 4 that the samples were put in rice bags. And sir, if a company is serious enough to invest in a mine, they will not use rice bags. They should bring proper bags and do proper work. So this is another sign that their work was just preliminary and sufficient.
Sir, I'm going to ask you one last time. You decided when writing your witness statement not to report NRD's actual expectations about hitting primary reserves of wolframite, and instead simply reported the conclusion that there would not be any wolframite to feed the plant. That's how you chose to describe this, correct?
Not, sir. Not correct.
And you will agree with me that when you wrote your analysis in 2012 of the NRD application, you conducted no independent analysis of the reserves yourself, correct?
My mission was not to conduct an independent analysis of reserves. Actually, NRD's mission was to conduct an analysis of reserve. My mission was to evaluate their report.
Can I ask you to please focus on my question? When
Yes, sir.
writing your analysis, you conducted no independent study of the reserves at Ritzero, correct?
I agree with you. That was not my job.
And you've never conducted an independent analysis of the reserves at Ritzero as of the time that you wrote your witness statement, correct?
You are right. That was not my job. It was NRD's job to conduct evaluation of reserves. It was not the job of the ministry.
Now, at the 5.2, the discussion of the samplings and analyses of the wolframite at Ritzero, near the bottom of that paragraph says, the concentrate that they took from their samples was dried, weighed, and analyzed in Germany at Stark's headquarters. You see that?
I see that, sir.
And in the application, they say the detailed results are available on request. You see that?
I see that.
You didn't request them, did you?
I didn't had to request. They were supposed to.
Them, sir.
I didn't had to request them.
Did you?
I didn't had to request them.
You're not aware of anybody at Minarena requesting and reviewing the detailed analyses of the wolframite samples that are offered, are you?
The report that was submitted to Minarena was enough for us to identify that they didn't perform well.
Now, if I could ask that that this be brought down and we start at page 101. This section 5 on page 101 starts the report in the 2010 application of NRD's resource and reserve estimations. Do you see that?
Yes, I see that.
Okay, so you'll see just from the first 3 bullet points that the only estimates were not scree wolframite at Ritzero. They, right in the first couple of paragraphs, summarize some estimates of other minerals at other locations, correct?
Correct.
Okay, if I could ask now that be brought down and just scroll the pages from 101 to 115.
I wonder if the pages could be scrolled when on the witness saying when the pages could be turned rather than the FDI person, please. If we go back to the beginning, and the witness should say when he's ready for the pages to be
I'm
turned.
not asking him to talk about any of the specific content. I'm not going to ask him questions about the language. I'm just making the scrolling an effort to essentially turn the pages that we're all sharing to see how long this section goes on. That's the purpose of it.
Well, if that was only the purpose, you could have just said it's however many pages long. You plainly are wanting to say something about the
Allow me to
content.
conduct the questioning. It would have been over if it wasn't interrupted. Can I just ask that the pages go until 115? Sir, you'll agree that your summary of the NRD provision of information about work done to conduct analyses and estimates of reserves at its concessions was very unfair in focusing on one or two small sections of these 15 pages of various reports, analyses, summaries of work done at all the concessions.
I do not agree. If I may clarify, expecting that a detailed resources evaluation report would just be made by 15 pages of unclear images would be very, very wrong. So this is just a superficial understanding of the reserves. And in fact, the people who made this report made it clear themselves that their plan for 2011 to 2017 was to do estimation of reserves. Actually, they know themselves that they never conducted proper estimation of reserves because they were planning to do so. But the government gave them 4 years to do that and they failed. So it is written in this report.
If we could go back to the witness statement, paragraph 15. And highlight paragraph 15. Again, sir, here you are saying what the expectations were of the contract that was entered prior to your starting with Minarena. And you say for an estimate of reserves, you expected a recognized expert setting out professional and detailed study of the level of mineral reserves at each site. Do you see that?
I see that, sir.
Now, you'll agree you could not find anywhere in the NRD file such a communication of expectations to NRD at the time the contract was entered, could you?
The contract was very, very clear at point number 5. It required NRD to do evaluation of reserves and a feasibility study. For any mining professional, for any geologist, you understand immediately what evaluation of reserves means.
And they did what they understood and submitted their report, but you said, no, it wasn't a recognized expert and that's what you expected. And I'm asking you, can you agree with me that the contract you just pointed to does not say anything about an expert, a recognized expert setting out this analysis? You left to the contracting party, NRD, to provide the analysis it saw fit, correct?
I do not agree. In this report you are showing me, they clearly say themselves that they failed to do the evaluation of reserves. And they were applying actually to renew the exploration license so that they continue.
Do you remember my question? I simply asked you whether you could agree that the contract doesn't mention having to hire some outside expert. You left to NRD what form it would submit its estimation of reserves. Can you agree with that?
I do not agree. The contract said it specifically that they need to do estimation of reserves and conduct a feasibility study, and they failed to do so.
Are you even familiar with the type of technology that went into the modeling of the different layers and images of the geography at the various concessions in the NRD application?
Yes, I read that report.
Right. That was the most advanced technology for analyzing below grade reserves that they were using in that report, isn't it?
If they believe that this was the most advanced technology, it's a good sign that they really failed to understand what is mining about.
Okay. In fact, Stark is itself a company full of experts on analyzing reserves to invest in mining and acquisition of reserves around the world, isn't it?
I don't want to dispute anybody's ability, but I'm just giving you the facts, sir. And the fact is that this company failed to implement its contractual obligations.
You can't identify any other applicant following the initial exploratory license phase that submitted estimates of reserves meeting the expectations you identify in your witness statement of thousands of samples and independent recognized experts quantifying the specific reserves in the location. Can you?
I can quickly, for the sake of an example, Rutongo collected 4,000 samples in just one tunnel. And another example, and I will be pleased that you come and visit that mine, it's New Bugarama mine. They provided an estimation of reserves. They installed 2 plants, and those plants are fully operational. You can
Now,
come and see them.
If those the reports included the estimating reserves using your expectations, you would have attached them to your witness statement and pointed to them as examples, wouldn't you?
If you are willing to get those reports, they can be shared to you, but they had no matter to do with NRD.
You had the reports available to you, correct?
I have many reports available to me.
So, and you had these reports you say followed your expectations, correct?
They followed my expectations.
But you didn't attach those reports to your witness statement showing them as examples, did you?
If I had been given the opportunity to give all the files that I had in my hand, I would have done so. But I focused on what was essential to NRD's matters.
You go back to, oh, I'm sorry, it's already up. You had it up, I apologize. Paragraph 15 of your witness statement, the bottom 3 lines, that you say that additionally there was a problem that NRD had attained an environmental impact assessment for an ore dressing plant at Rutsiro, which never in fact operated, you say in parentheses, and an abbreviated and inadequate EIA for Nyatabindi. And then it carries on, but not for any of the other concessions. That's a criticism you lodge of the report, inadequate environmental analyses. And you say there's these only 2 aspects of an environmental study at all submitted by NRD, correct?
Can you repeat your question, please?
Sure. You criticize the environmental analysis in the application, and in doing so, you identify NRD as having provided only these 2 environmental discussions and analyses at all, correct?
Actually, what I said, and it is clear in my statement, NRD had been given 5 concessions. They only conducted an environment impact assessment for 1 plant, not even 1 concession, and an abbreviated assessment for 1 deposit. So they didn't provide environment impact assessment for the 5 concessions. That is what I'm mentioning in my statement.
If we could go back to C35 and start at page 121. Do you see 6.5 near the bottom? Sir, proposed activity plan in environmental mitigation over the next 5 years as of then. Do you see that, sir?
Yes, I'm reading it.
If we could go back, it continues. So we'll have to, it's not just this one section. I'm going to ask you to put the pages up side by side. starts on page 121 and section 6.5 goes through page 124. Are you ready to turn the pages, sir?
Yes, please.
Can you put pages 123 and 124 up side by side? So you'll agree that over the pages covered by section 6.5, in fact, NRD in its 2010 application discussed the environmental mitigation plans for Nemba, Rutsiro, and Nyatabindi over the next 5 years, and then mentioned briefly general intentions for 3 other areas of the concessions, Kisai, Sabaya, and Mara, correct?
Not correct. Actually, here they are saying that they planted trees in Nemba, they constructed a dam in Nayatubindi, and Gichie, Sevilla, and Mara, they are saying what they intend to do. But my statement says that they never conducted environment impact assessment. And this is correct because here there's no way where they say that they completed environment impact assessment for these concessions. So this is what I was saying.
Can I now ask that we turn to page 143? At page 143 of NRD's 2010 application begins the environmental impact assessment report for Rutsiro plant, correct?
Correct.
That environmental impact assessment report that you say wasn't included is actually 80 pages long in the application, correct?
This environment impact assessment is just for one plant in Rutsiro. It's not even for the Rutsiro concession.
Sir,
it's not a
my question was,
yes, please.
This environmental impact assessment report covers the next 80 pages approximately of the application. Is that correct?
I don't remember the number of pages it has.
Can I ask that we go to the end of this section? And I believe, well, let me find it myself first. The end page, I didn't mark that down. All the way to 224.
Just while Mr. Cowley's looking, his earlier question said the environmental assessment report you say isn't included. But just, I think, not sure what Mr. Cowley meant to say that, because the witness statement does say in terms, bottom of paragraph 15, that the environmental impact assessment for the ore dressing plant was made. So that may have been a slip by Mr. Cowley.
No, I picked up on his prior answer. And it goes to page 223, does it not, sir? Do you agree that the environmental impact assessment report within the application goes all the way to the last page with content on it of the report, 223? If you could.
I didn't get your question, but I'm seeing here it is written page 80. So I don't really get.
Can I ask
what I'm asking to confirm.
FTI to go to page 223? that's the last page of the environmental impact assessment report that starts at page 80, correct?
I think so.
Now, if I could ask FTI to bring up C36. Sir, in addition to the environmental impact assessment report, within the application, NRD also submitted to Minarena the environmental impact assessment for Nyatabindi, correct?
You're right.
And that's this document.
I think so.
Now, if I could ask that C43 be brought up. And as part of its application process and attempts to discuss it with Minarena, NRD submitted in November 2011 an updated environmental mitigation report for Nyatabindi, correct, sir?
I see that mission report. Yes, I get it.
That's C43, correct?
Yes, I see that report you are showing me.
May I ask that C44 be brought up? C44 is a letter from NRD transmitting the updated environmental impact assessment for Nyatabindi to a number of parties. And it concludes on the second page, asking on their end, others work with NRD to continue to push forward by discussing the next steps with experts as to road access, so further remediation efforts can continue at that facility, correct, sir?
Sorry, I didn't understand your question.
This is the transmittal letter of the updated environmental impact assessment report for Nyatabindi, correct?
So can I be given some time to read this letter if you want me to confirm anything?
Please, I didn't think I just asked you to, if that's what it is, I didn't cut off any attempt to read it. So, yes.
Yes, I finished reading.
Do you recognize this as the transmittal of the updated environmental impact report for Nyatabindi, correct?
What I recognize is that they are transmitting a report to the mayor and asking an expert from the district to come and assess the work done by NRD at Nyatabindi, and asking an expert, an engineer, to come and agree with them where the maintenance of the road should be done. And this is in no way in contradiction with what I said in my statement. I said,
I'm not asking to argue with you about anything yet, and I'm not asking you to argue with me about whatever point you think I'm going to make. I just asked you, do you recognize that this transmittal letter forwarded to all the parties shown here, the updated environmental impact assessment report for Naya Tabindi?
Not as you're mentioning, it's a rapid environmental assessment. It's not an environment impact assessment study.
Can we go
It's
back
just
to
a matter of
exhibit?
clarification.
I'm sorry if you didn't hear me. Can we go back to exhibit 43, C43, sorry. So the letter we were just looking at, you recognize as, well, I'm sorry, I must have called up the wrong one. What's the rapid? I'm sorry, I said the wrong number. C36? You recognize the letter that we were just talking about as transmitting to all those individuals this report, correct?
You are right.
And it asks at the end of the letter that experts on the respondent side, experts from Rwanda and its locales that were involved in the concession area, to provide experts and work on development of a road that would be utilized to conduct further anticipated remediation work. So the letter ended by saying, we want to work with you so we can continue our remediation experts, identify experts and work with us. That's how the letter ended, right?
That is what I'm reading. Yes, you're right.
You're not aware of anyone ever doing that and continuing to work with NRD on that issue, are you?
I didn't get your question properly.
Nobody on Rwanda's side came forward with experts of their own, worked with NRD to continue to explore the siting of the road for additional remediation efforts by NRD, correct?
This letter was addressed to the mayor, not to myself. So I don't know what happened after this letter was addressed to the mayor of the district.
That's what I was asking. You're not aware of anybody actually working with NRD in response to its letter to do what it asked, right?
It's not as simple as you're suggesting. This letter was addressed to the mayor of the district, and you're asking me to confirm something for which I don't have any information. I don't want to speculate. I was not there, and I was not the recipient of the letter.
If I could ask to go to paragraph 58 of Mr. Mena's witness statement. In paragraph 58 of your first witness statement, sir, you talk about Rotungo's application. Do you see that testimony?
Yes, I see that.
Now, Rotungo as a concession, that's Tinko as the applicant, correct?
Sorry, can I be given a minute and go through the paragraph so that I can be able to answer to your questions? Yes, I've finished.
This reference to Rotungo's application, Rotungo's actually, excuse me, the applicant for the Rotungo concession is actually Tinko and its joint venture partner, correct?
You're right.
The joint venture partner is Rwanda. correct?
Yes, Rutongo is a joint venture company where the government of Rwanda has shares.
And at this time of its application, when I say this time, at the time of the application for extended licenses past the exploration stage, Rwanda was the overwhelming majority owner of the joint venture for Rutongo, correct?
I think so.
Now, you'll agree that you include this information in paragraph 58 because what you're trying to convey to the tribunal is, unlike NRD, whose application you heavily criticize, you point to the Tinko and Rwanda application for Rutongo's concession as the better application and that met your expectations, correct?
This is an example among many, but you are right. Rutongo application was much better than NRD's application.
That's what you're trying to convey by including this information, correct?
This is what I agree with.
Okay. Can I ask that R42 be brought up? And R42 is the Tinko application submitted for the Rutongo concession, correct?
Yes.
And if I can ask that we go to page 75 of that application. Section 10 of the Tinko application for Rutongo's concession, in section 10, Tinko discusses the environmental impact assessment element of its contractual obligations, correct?
Can you repeat your question, please?
This is the section 10 that we're looking at, where Tinko addresses how it says it and Rwanda met the environmental impact assessment obligation in the contract.
Here, what I read is that they contracted a company. That company was given an environment impact assessment project brief by the Rwanda Development Board, and that they had started to complete an environment impact assessment study.
Sir, this section 10, when you received and reviewed the application from Tinko for the Rutongo concession, you understood section 10 was trying to speak to how Tinko and its joint venture partner believed they met the environmental impact assessment obligation in the original exploratory license contract, correct?
I didn't understand your question.
Okay.
Sorry.
You understood that they're addressing what they believed was the contractual obligation to inform Rwanda what environmental impact assessment had been done in the initial exploratory years of their contract, correct?
Sorry, I'm not understanding the question. I'm very, very sorry.
I will.
Maybe it's because I'm reading while at the same time you're asking me a question.
You understood when criticizing NRD's information in its application regarding environmental impact assessment that you were criticizing their ability to meet an obligation of the contract, correct?
My report was giving facts, and the fact is that NRD didn't submit an environment impact assessment for all the 5 concessions.
Sir, and the reason you addressed that and raised that criticism is because you thought you were speaking to an element of the NRD original contract, correct?
Oh, sorry, I didn't get again. If you can speak slowly, maybe I will understand better what you are asking me to confirm or not confirm.
Okay, well, let's move forward. I do have a time issue, and so I need to move forward. To get back to Tinko. In reviewing Section 10 of Tinko's application for Rutongo, you found it acceptable, right?
If you can allow me, read at the last paragraph. They say that they conducted an environment audit. And in our process, you either provide an environment impact assessment or an environment audit. And here what I'm reading is that the company passed the audit, and the audit is much difficult to pass than just the environment impact assessment. So this confirms what I said in my statement, that Rutongo did much better than NRD.
Focusing on the aspect of Tinko's application where they believed they needed to address an environmental impact assessment, they said they just hired someone at the time of the application, correct?
You are correct.
And you didn't find that to be a concern, correct?
Actually, in Rwanda, you are not allowed to conduct the environment impact assessment yourself. You are supposed to hire someone accredited by the Rwanda Environment Management Authority and by the Rwanda Development Board. So it's a duty to hire someone, as NRD hired Dr. Fabien. So this is normal process.
So you didn't find a concern that only at the end of the initial contract term, the initial license term, they first hired such an independent environmental assessor to write a report, an environmental impact assessment, and that they anticipated that report would be done in 12 to 18 months after the application. You did not find that to be a concern, correct?
Actually, I said that Rutongo had already passed an audit, and an audit is much more difficult than just conducting an environment impact assessment. And NRD failed the easiest thing to do, which was to present an environment impact assessment. And that is what I'm saying in my statement.
Sir, I'm not asking you to focus on the Tinko application. You were not concerned that they never hired anyone to do an environmental impact assessment prior to the end of the license and told you that it wouldn't be ready for 12 to 18 months, correct? Can you agree you weren't concerned with that?
I don't understand where the concern should be.
And so you agree you'd had none, correct?
Sorry, I didn't get your question.
Tinko,
Because you're asking me if I had a concern.
let me ask
I
the
didn't
question
have
again.
a concern.
I'll ask the question again. I'll ask a different question. Try to address it a different way. Tinko received a long-term concession for Rutongo, correct?
Tinko received a large-scale mine in 2015. You are right.
And they never came back, at least according to your witness statement and what you provide as exhibits, they never came back and provided that environmental impact assessment before getting that license, correct?
Sorry, this paragraph you are showing me, it's mentioning that in 2011, they were planning to have an impact assessment report ready in 18 months, meaning mid-2012. And they got their license in 2015. It means 4 years after the report you are showing me.
And in all that time, you did not receive an environmental impact assessment report that you could attach to your witness statement for Tinko's application, correct?
I didn't attach the environment impact assessment to Rutongo to my witness statement. Yes, you're right.
Well, you did attach one. You attached R43. Can we bring that up? This is the environmental impact assessment report you attached to your witness statement, correct?
Yes.
And this is the environmental impact assessment that Tinko obtained and provided at the beginning of its exploratory license period. Not at the end and the 12 to 18 months later that they said they would get, but the one you already had from the beginning, right?
I don't know what you'd like me to confirm, but here you are showing me an environmental impact assessment of 2008. You showed me a plan in 2011. The plan confirms that an environment audit was completed. And I say that completing an audit.
My question, this environmental impact assessment report that you attached to your witness statement was a report that Rwanda had from Tinko before the expiration of its exploratory license, correct?
This is correct. This is a very good sign that Rutongo immediately completed an impact assessment in 2008.
At the beginning of its exploratory license, correct?
This confirms their seriousness.
And you'll agree, if you had an environmental impact assessment from Tinko and its joint venture partner, Rwanda, at the end of the exploratory license, as promised, you would have attached that to your witness statement?
So there have been 10 years since 2011. I don't remember with details what was submitted in 2011 and 2012.
And you can't agree with me that if you had it, you would have attached it to your witness statement instead of an old dated one that didn't meet the contract requirement you were looking at?
I think speculating on this on my side would be not appropriate. So I would not want to speculate on data that I don't remember.
The lack of any defined standards as to what applicants were supposed to provide in order to meet the different elements of their exploratory licenses permitted Rwanda to apply complete subjective analysis such that it could reject everything NRD said about environmental impact assessment as insufficient, and yet accept the statement, we'll give you a report later, as sufficient for a different applicant, right?
I totally disagree with your suggestion.
Our
2008 law was very clear. The 2008 law was very clear about what was supposed to be submitted. The 2006 contract was clear. The 2014 law was very clear. So I totally disagree with your suggestion.
The 2008 law, sir, and excuse me, the 2006 time period and the contract being formed, you'll agree that if there are any statements of general guidelines applicable to every applicant for a concession, they would be provided in your witness statement as the standard that everyone had to meet and that you were applying, correct?
Not correct. If I can give a short and quick example, if you ask me to respond to an email, you don't start telling me, but you start by switching on your computer. So these are basic things anyone knows, that before responding to an email, you need to have an operational computer. So if a government tells you and you agree to conduct estimation of reserves, you know that you will switch on your computer. Just to link that example to what I'm trying to say.
So to be clear, you're agreeing with me that there were no written guidelines for all applicants and Rwanda to look at to see that they applied to everybody and exactly what they were. And your argument is they weren't necessary. But I want to focus on the first part. You do agree with me that they didn't exist in writing, right?
I don't agree. In 2008, Rwanda had a law which is written, available to anyone, and that was the guideline at that time. In 2014, we had a law which is written and available to anyone. That is a guideline.
Can I ask that C-140 be brought up? C-140 is the documentation concerning the tender of the NRD concessions that occurred in 2016, correct?
You're right.
I could ask that the FTI turn to pages 7 and 8. Focusing at the beginning of section 2.11, it states the submission for the applicants who want to participate in the tender. Their submission shall include the following documents, and then it lists in detail all the documents that are to be provided by the applicants, and that continues on to the next page all the way through section 14. Do you see that?
I see that.
I could ask that we turn to pages 11 and 12. Beginning on page 11, the tender informs all applicants generally how their submissions are to be evaluated, point by point, every aspect that they're supposed to talk about in those submission 1 through 14 guidelines. It says what Rwanda believes needed to be done to meet that element, correct?
You are correct.
And that continues for 2 more pages through 13 and 14, correct?
You are correct.
Now, you will agree with me, won't you, that the reason in 2016, public statement of not only the elements required to be provided to Rwanda in order to be a successful applicant for these concessions, and a statement of exactly what Rwanda believed was required and what was meant, in using your hypothetical, how it believed one would successfully turn on the computer before typing the email. The reason it did that in the tender is because it didn't exist anywhere else, anytime before, for the applicants to look at. Correct?
Not correct.
Prior to the
Yeah.
tender in 2016, can you point to any publicly available documentation explaining how the various criteria for applicants for mining concessions would be evaluated as to all the elements that they had to supply?
If I can explain, here you are showing me a document prepared by the government whereby we are trying to look for potential good candidates. And then we are showing them the criteria that will be applied in selecting them. And in 2006, the candidate had already been selected. The 2006 contract is the agreement between the government and the selected candidate. So these are two
If I
different
understand
things.
your answer, if I could just briefly ask you to pause. You're making an argument with me right now about why you think this is different, and I'm simply trying to focus you on a fact. The reason that this is in the tender, spelled out in the document, is because Rwanda couldn't refer to an already existing public statement of these elements for how it would evaluate the required aspects of the submission. It didn't already exist to just refer to, correct?
Sir, you know that in every business, there is evolution and there's progress. In 2006 and 2016, that is 10 years gap. So we have been progressing and we have been requiring more complicated criteria to admit people into the sector. But NRD was very, very lucky to be given a contract without even fulfilling these
Please answer
conditions.
the question. Please stick with the questions. To get through your day, it's going to be very tough. And And
I would ask Mr. Carrier to stop the implied criticism. I think these all have been answers to the questions.
I strongly disagree, and I just would like the witness to focus on what I'm asking. If there were any other, strike the question I started. At the time of the 2016 tender, there was no prior publicly available statement of how all the submission elements would be evaluated that could have been referred to, correct? Can you agree with me on that?
I disagree. In 2006, there was no tender.
I didn't say anything about 2006. I didn't ask you about a tender in 2006. Please address the question.
Can you repeat then the question?
In 2016, the reason the 4 pages of description of how the elements of a tender would be evaluated were set forth in the document is because they didn't exist anywhere else to be referred to.
I don't understand what you are trying me to confirm. I said that there was a 2008 law and a 2014 law. So those were the reference documents. When NRD applied in 2006 and got their license, we had the 1971 law. So the 1971 law was the reference in 2006. The 2008 law was the reference in 2010, and the 2014 law was the reference in 2016. So I don't know what more I can give.
And instead of just relying on the law as the reference, you do agree at least that Rwanda took the time and effort to set forth an explanation of the criteria that would be used to evaluate whether the applications met the standards required to be submitted. Can't you agree with at least that?
I agree with the fact that in Rwanda, we abide by the laws and we use the law to evaluate the applications.
Mr. Cowley, my recollection is that the witness did agree with what you were putting to him and explained that in Rwanda over the 10 years, they had been making progress in the assistance that they were providing to those seeking concessions. Is that right, Mr. Imena?
Yes, you're right, sir.
Thank you.
May I ask that we turn to page 16? Section 2.38. In the tender, Rwanda made it clear that the submissions and the information that would be provided would look out in terms of plans and budgets for 5 years of the project, correct?
Yes.
And that's regardless of how long the license that would be issued actually would cover, correct?
Can I get your question again?
Regardless of how long the license period would be for a successful applicant, its submission was only to provide plans and budgets for the first 5 years of the license.
Yes, you need to provide a plan and budget for the first 5 years.
Even if the license that would be issued would be longer, correct?
You're right.
And in fact, the successful applicant in 2016, Fair Construction, was given a 15-year term license for the concessions, correct?
Correct.
Mr. President, I believe we're scheduled for a break in 4 minutes. I'm about to change topics altogether, so I think.
Yes, these schedules that are prepared, I think I've already indicated, are not very satisfactory. I think we would like to go on for another half an hour before we break, just to have a more balanced break, because the schedule only provides for a quarter of an hour break, but we're taking our lunch break at the first break. So if that's acceptable, can we go on for another half an hour?
Certainly, I just wanted to raise it. Bear with me one moment. I'm trying to locate in my system a document that I had trouble bringing up. If I could ask that we bring up C62. Mr. Mena, C62 is an August 2011 letter from Mr. Kamanzi, your predecessor at
Yes.
ministry. This is the first response to NRD after its November 2010 application, correct?
Yes, I think so.
And here it says the reaction is you didn't comply with the contract. We have to talk about how the licenses would be operated going forward, correct?
Yes, I see that he's telling NRD that the contract was not fully executed. There was no presentation of report of reserves and mining feasibility studies. Yes.
Now, if I could ask that C34 be brought up. C34 is a letter from Mr. Kamanzi again to NRD, further extending the license period so that, in his words, because it has not been possible to conclude the contract in the above time of extension, I understand the absolute necessity to conduct this agreement, to conclude this agreement as soon as possible for strong investor confidence. So he's extending the time period further, correct?
You are correct.
Now, there wasn't in between those two letters a resubmission by NRD changing the licenses it was applying for or otherwise abandoning the November 2010 application in full, correct?
Yes, I think that's the situation. Yeah.
Can you agree with me that if one were to read these two letters side by side as messages to NRD as to what Minarena's reaction to the November 2010 application is, one would have to conclude that the reactions are entirely inconsistent?
I don't agree.
In the first letter, there's no mention of needing to conclude quickly a contract meeting the parameters of the application, correct?
Can you repeat, please?
Sure. And maybe we could put them side by side because I don't want this to be a test of Mr. Amena's short-term memory. C62 and C6 and C34, the two letters. So in the earlier one in August, there's no mention here of acknowledging that Minarena is going to work quickly with NRD to conclude a contract for the licenses that were sought in the 2010 application, right?
In the 2011 letter, April,
August. I believe.
August, yes. Our NRD made an application. The application was received, but was deemed not satisfactory. NRD is given 6 months to complete what is not satisfactory, and the ministry to conclude an agreement. Then in the 6 months, the process didn't yield any final decision. Then the minister is giving another 6 months. That is what I'm trying to interpret from these two letters.
The fair reading of the August letter is that the application for the 5 licenses would need to be revised for any contract because in the terms of the letter, the contract wasn't satisfied. So they needed to discuss the terms of what licenses would be in play going forward, correct?
Sorry, what I see from the August 2011 letter is that the work from NRD was not satisfactory, but the ministry is extending 6 months in order, as reads the last line, in order to allow us time to determine the future of these concessions. And the next letter says that, okay, we have an idea on the future of these concessions, and we would like to give you time so that we conclude an agreement.
Sir, in the second letter, in February, I believe it is, if I can read it correctly, yes, February 2012, the minister isn't mentioning reconsidering what licenses would be subject to discussion, correct?
No details, yes, you are correct. No details are given in the letter.
Well, there is a detail that the ministry at that time recognized the absolute necessity to conclude an agreement as soon as possible in order to promote strong investor confidence. You see that detail, correct?
I see that, correct.
So the message to NRD, reading that letter, is we're no longer being given pressure to give up the application for the 5 licenses we sought, rethink everything. And instead, we're now being told the ministry agrees we're going to sit down based on that application and as quickly as possible conclude those contracts. That's the message, right?
There's no way the minister is saying that the 5 concessions will be given. The minister is saying, I want to conclude an agreement as soon as possible. On which concessions, those are the details that are not included in the letter.
Well, he also doesn't hint at the idea that in February 2012, that it's in doubt and NRD, strike the question I started. He does not even suggest in the February letter that that was a preliminary topic that had to be resolved before a contract can be discussed, does he?
No.
And you'll agree that before you can sit down and negotiate the terms of the contract for the license, who was going to do what, when, the various rights and obligations of the parties, the first thing that had to be done in the process was agree on the parameters. What's the concession at issue, for how long you're going to have it, What are you telling us you're going to mine for and how you're going to do it? We need to agree on that. Then we know whether the terms we're negotiating are actually achieving what we're expecting to achieve, right?
No, I think if I'm an investor, I first look at the contract that I signed and see if I'm satisfactory in fulfilling all my obligations. But here, the minister has already told the investor that there are things that are not okay. So to me, that is step number one to anything that will follow.
Sir, I didn't ask about investors. I'm not sure what that answered. So I apologize, but I'm going to have to ask the question again and make sure we're talking about the same thing. If the two parties are going to sit down as soon as possible to negotiate the terms of a license, before they can negotiate the specific terms of the rights and obligations in the license, you needed to have an understanding, what's the license going to cover? What concession? What minerals? How long? That had to be understood before you can negotiate the terms of the license that provided for it, right?
I think it's not necessary to interpret these letters beyond the message that they contain. The letters are very clear. I think I have not the capacity to make any further interpretation to these letters that are clear enough to me.
Now, Mr. Cowley knows very well there are letters in between these two letters, which he hasn't taken the witness to, and I think he needs to be very careful with his questions here.
Mr. Hill, I believe that's a completely inappropriate interjection, given the nature of the question I'm asking.
But it's not, I'm afraid. I chose my words quite carefully because I'm quite disappointed with some of the questions so far, which don't give a fair impression of the letters that pass in between. And I've held back, but it's gone on, and I do need to intervene to mention this.
Sir, I strongly disagree that you've held back. And I strongly disagree what you said was appropriate at all. And the witness knows I'm asking a general question about how to discuss, how to negotiate a contract for a license. You know that as well. And I would appreciate being able to ask the questions without interference. Sir, can't you agree with me that in order to sit down with an applicant and negotiate a license for mining concession, one needed to first agree what concession we're talking about?
Yes, that's part of what needs to be agreed upon.
So you first need to address whether you're going to go forward as the applicant requests and discuss the concession that they're seeking at all before you decide, let's negotiate the contract for it, right?
I first read the contractual obligations. That's where I start.
And then you would do that in order to make the decision. Are you going to go forward with this applicant and discuss the concession they're seeking at all? If you decide no, then there's no contract to negotiate, right?
Yes, that's the essence I'm reading in these letters.
So if you're talking about scheduling a time to, as soon as possible, sit down and negotiate the contract, that means you had to already make that preliminary decision. Are they going to pursue and you're going to negotiate licenses for the concessions that they applied for, or something different, right?
No, I think you know it better than me. Negotiations are a process. So it's not something written in the rock. So it's a process where the two parties discuss and they end up concluding an agreement that is suitable to both of them. So the ministry here is showing flexibility in saying, okay, we are allowing both of us time so that we can conclude an agreement.
And that was sent on February 22nd, 2012. If a meeting were set up on March 1, 2012, what concessions were the contracts or concession were the contracts going to address with NRD?
If you may allow, let me not speculate on things that I can't answer. but let me rely on facts. After this February 2012 letter, there were other letters sent by the minister. So those are the facts on which...
I'm asking you to place yourself in NRD's position. It received the February 22nd letter, and on February 22nd, it's reading it and talking about as soon as possible, March 1, sitting down to negotiate a contract. At that time, based on your understanding of the parties' communications, what were the contracts going to cover?
Sorry, sir, that's what I said, that I think it's not appropriate to speculate. Let's just base on facts. So there are letters that followed this February 2012 letter.
So before you go on to the other letters, can you agree that even knowing the full file, you can't say that on February 22nd, NRD would be able to have any understanding of what concessions it was to sit down and negotiate contracts for? Correct?
I'm sorry, I do not agree with your suggestion.
Then please tell me what concessions were to be covered by these contracts according to communications from Minarena to NRD up through February 22nd, 2012.
He's asking again, he's asking the witness to speculate on things without showing him the material, the letters that pass immediately before this second letter, which answer his question. And it's not fair for Mr. Cowley to deliberately not go to the previous correspondence and then ask the witness to speculate in this way.
Mr. President, I do not know what's being referred to. I have absolutely no intention of doing anything unfair. I can't imagine that counsel, after the type of testimony that's been provided and the wild opinions about what everybody must have expected at different times based on different things, that now a line is going to be drawn suggesting that this witness does not have the ability to look at a letter and say what the ministry would have understood it to mean and what NRD would have understood it to mean. That's the only question.
The question is to put it in the context. He's been asked. The question asked the witness to put the letter in the context of what was going on at the time and what people would have thought. If he's going to do that, he needs to show him R018, which passes immediately before that and answers his question.
Yes, I strongly disagree about the coaching. This is completely inappropriate intervention, and I will take the time to look at the document. I have absolutely no intention to leave something out that's relevant. I don't think it is to my question, but I would like the opportunity, given this, what I consider to be remarkable intervention and representations on behalf of the witness. But I would like to do that during the break.
I think that's a good idea, Mr. Cowley, because this all started off with your suggesting that these two letters were not compatible or consistent. And for myself, I am inclined to agree with that. And that then raises the question of what links the two. If there is relevant correspondence linking the two letters, that may provide the explanation for an apparent inconsistency between the two. And the second letter is talking about the contract. The first letter is talking about licenses.
Yes, sir. May I have during the, can we take the break and I'll look up this document?
Well, I think it'd be a good idea. We'll take the break now and come back in half an hour.
Okay.
Okay, we're going to go ahead and open up the breakout rooms right now. Okay. Mr. President, the witness is in the waiting room. I will go off camera and wait for you to ask for him to be brought in.
Very well.
Mr. President, can you just tell us what time you would like the break so I could keep my eye on it?
Right, that's kind of you. I should think about 4 o'clock. or perhaps a bit before, in an hour and 3/4, something like that.
Thank you, sir.
You ready to proceed, Mr. Cowley?
Oh, yes.
Yes, thank you. Could the witness be invited back, please?
All right, we're bringing him in now.
Mr. Mena, well, I'm sorry, FTI, can you please bring up the exhibit that Mr. Hill insists the witness review, R18? Mr. Mena, before the break, counsel for the respondent insisted that you needed to review this before answering my question. So by all means, please review this.
Yes, I have finished reading.
Okay, can you bring back up C34, please? Now, Mr. Mena, to pick back up with the questions that I was asking, in February 2012, you'll agree that your predecessor was informing NRD that the parties should, as quickly as possible, as soon as possible, excuse me, negotiate the terms of a license. Excuse me, complete the terms of a license.
You're right.
So at that time, there was no understanding between the parties as to whether it was 5 concessions that were going to be ever approved, something less than 5, only 2. You'll agree that that was not yet resolved between the parties as of the letter that Mr. Hill insisted that you read, correct?
Actually, I think our counsel that I was allowed to look at this letter, and now I understand properly the context. The first letter of 2011 shows that the report was not satisfactory. And this one of January gives a clear position of the ministry that they are okay to move forward with negotiations on 2 concessions. And if NRD is happy with that proposition, they can move forward. And the February letter says, please, we have not finished to discuss on the negotiations, so I'm extending to you more time. So to me, the message from the ministry had been very clear to NRD that you are given two concessions and we are ready to negotiate on them.
Well, it says something more than you've now switched the language. You suggested that the February letter says to conclude negotiations. It actually says to conclude the contract, correct?
Yes, so it's just the language. It's just the language, yes. But I think the context is the same.
It's very different language. So they were being invited in to negotiate contracts for operating mining concessions. your testimony is it was only going to be 2, correct?
Yes,
Okay, first question, which 2?
that was to be chosen by NRD.
And first of all, to be clear, for the sake of the record, the claimants continue to stand behind Mr. Marshall's testimony that the discussion that is purportedly confirmed in R18 did not occur. But putting that aside as a disagreement as to who said what to whom in December, your testimony now is the ministry had approved the granting of concessions, any 2 to be chosen by NRD, and when they came in as soon as possible to negotiate contracts, those contracts would be for licenses to operate 2 mining concessions, correct? That's your testimony.
Not correct. Can I clarify what I want to say? NRD had 5 concessions. The ministry evaluated and said, okay, we can allow you to negotiate with us 2 concessions. In this letter, the names of the concessions are not mentioned. But what I recall with my experience at that time, it is the concessions where at least NRD tried more work compared to the other concessions. And those concessions were Rutsiro and Nemba.
So although it's not named in any letter, you say the ministry had already made a decision as to which 2 concessions it would award contracts and negotiate specific contract terms for licenses for NRD to operate those 2 concessions going forward, correct?
The ministry was happy to move forward in negotiations with NRD on 2 concessions.
And the negotiations.
To me, what I recall, on our side, Nemba and Rutsiro.
Please just focus on my question. I'm trying to see that we have agreement here, that it's not just ambiguous negotiations. They weren't inviting them in for a negotiation of any and all issues. They were inviting them in as soon as possible to conclude contracts. And you're saying the ministry intended in those discussions, those contracts would be for Rutsiro and Nemba, correct?
You are right.
And the contracts that they were saying should be concluded as soon as possible were to operate those 2 concessions for mining going forward by NRD, correct?
Yes.
So NRD would read the February, it's perfectly reasonable for NRD to read the February letter, just as you do, to say, we're no longer saying that you don't get any concession and license going forward yet, because you didn't invest $40 million yet, right?
You're right.
And it would perfectly reasonable for NRD to read the February 2012 letter to say, the ministry is no longer saying they don't get any concession or license going forward at all. They don't qualify as an applicant because they have not sufficiently identified reserves in at least 2 specific concessions, unnamed in the letters, but Rutsiro and Nemba, the ministry is not saying they don't qualify as an applicant. They're going to give them a contract, right?
It's not as simple as you're trying to put it. The ministry here is saying you have 5 concessions. We know you didn't perform, but we are generous enough to allow you at least to negotiate for 2 contracts. Here you see that NRD had said, no, you give us the 5 or nothing. And then the ministry says, no, we are generous, you can take 2. But if you still want only the 5, then we are happy that you relinquish them. It is clear in the letter. So
And I'm not saying anything different in my question, sir. You're not focusing on my question, but I do notice that you keep changing the term for concluding a contract, which is in the letter, to negotiate, which is ambiguous as to what it may refer to. And I want to be specific. My question to you is, it was reasonable in February 2012 for NRD to read the minister's letter, to say, come in, we will conclude contracts for licenses to operate, you say 2 mining concessions going forward, and you don't have to worry anymore that you get nothing going forward because you have not sufficiently identified all reserves in all concession areas as of the application.
Mr. Cowley, Mr. Cowley, you keep using the expression going forward. Can you be more precise as to what you mean by that? Is there any length of period going forward that you're putting to this witness?
I have not put it to this witness on purpose because it's not in the letters, and I'm not suggesting it's hidden in the letters anywhere. But concluding a contract is what the minister did say, and I'm just trying to get agreement that it was by this witness that he understood it to mean what, as the tribunal knows, we've been saying the NRD understood that these other issues were off the table. The witness, I just want to focus on the fact that we're no longer talking about application, we're talking about contract terms. Whether they reached agreement on the length or not, I am not suggesting is shown by these letters, and that's why I'm not suggesting it in my questions, because I don't mean that his answers imply that. So, Mr. Amena, you will agree that it was reasonable for NRD in 2012 to read the minister's letter to say it was not disqualified from getting a license for any concession because it failed to provide sufficient estimates of reserves at every concession, right?
I will agree that the ministry made it clear to NRD that they failed to fulfill their obligations, but the ministry gave them the opportunity to negotiate contracts or agreements or license as you wish for 2 concessions, because the ministry wanted investors and was much supportive to NRD. That is what I think these letters are telling us.
Sir, you will agree, will you not, that the February 2012 letter does not say you did not qualify for anything because you have not met the contract terms for any concession, but we'll still talk to you, right?
Excuse me, I think, as I explained it before, it's not appropriate to me to make further interpretation rather than what is written. I can't make an interpretation for NRD. I can only explain the facts that I know.
Right. And you do know as a fact in the letter, they didn't mention anything about not qualifying for any concession. All they talk about, all the minister talks about is they'll conclude contracts, correct?
I agree that the minister in his first letter of 2011 says you didn't perform as expected. But in his second letter says, we are happy to discuss with you 2 concessions. In his third letter, he says, I'm giving you more time so that we can conclude the contract or the license or the agreement. That is what I agree.
And you'll also agree that it was reasonable for NRD to read the February 2012 letter to say that the minister is not taking the position that NRD will not qualify for a license for any concession because it failed to provide sufficient environmental impact assessments for every concession. Correct?
Not correct. What I agree is that I'm not in a position to make an interpretation for NRD. I'm making what I remember of the facts, and this is what I'm trying to tell you.
You will agree, sir, that these issues that predominate in your witness statement, all the reasons why NRD didn't qualify for anything and would not get any license for any concession because it failed to invest $40 million, because it failed to specify the exact reserves at every site, because it failed to provide adequate environmental impact assessments at every site. You'll agree that as of February 2012, the minister advised NRD it was not standing by such claims and it was willing to conclude contract negotiations for at least one, if not more, licenses for concessions. Can you agree with that?
I agree with that, and that is a sign that the ministry was very indulgent and generous to NRD. I agree totally with that.
So won't you agree, sir, that when you prepared your witness statement that said all these reasons why NRD had to know it was not entitled to anything, you purposely failed to state what you knew to be true, that your predecessor minister already said, we're not standing by these issues that any further as of February 2012. NRD we will negotiate at least one, if not more, contracts with NRD going forward, right?
It's not only my predecessor who told NRD that. I met NRD and told them, please, we are willing to negotiate with you. I had a meeting. It is written in my statement. Please, we are willing and ready to negotiate with you for one or two concessions. It's a fact.
And
so it's clear to me.
So it's true, sir, is it not, that all these issues that you dwell on at such length in your witness statement as to the failings of NRD in its 2010 application, you know, as a reality, did not actually block the award of licensed contracts for at least one, if not more, mining concessions. Those were not the issues that prevented the parties from going forward, correct?
I totally disagree with your suggestion. What I agree with is clear in the letters. NRD was not satisfactory in completing and implementing its contractual obligations, but the government gave NRD a chance to at least negotiate for one or two concessions, although the government knew that NRD was not satisfactory in completing its obligation. That is what I agree with.
Can I ask that C45 be brought up? C45, sir, is a September 13, 2012 letter, again from your predecessor, Mr. Kamanzi, to NRD, further extending what's referred to as the previous license of NRD, correct?
Can you repeat your question, please?
This is a September 13,
Excuse me. I think the problem, you are showing me a paper and you ask a question at the same time. So if you can give me a minute, I can read and then.
Absolutely. I have no trouble with that. Just let me know when you want me to repeat the question.
Yes, please, you can ask it.
This is a September 13, 2012 letter from your predecessor, Minister Kamanzi, to NRD, further extending what is referred to as the previous license for 3 more months, correct?
Correct.
And just as an aside, sir, to be clear, because I don't want this to feel like it's some sort of battle. When I ask that they bring up a document and ask you a question about it, I have every intention to give you whatever time you need to read the document before answering. I'm not demanding an answer immediately. So if I forget to say, please let me know when you're done reading. Just take the time to read it and let me know, okay?
Okay, noted.
You'll agree that this letter to NRD does not state that only 1 or 2 or 3 previous licenses were extended. As of this time, your predecessor was extending all of them so that the work on the new contracts could continue, correct?
I do not agree. This letter is extending the licenses for all the concessions for, I think, 6 months or something like that. It doesn't cancel the previous letters. And let's keep these letters in the same context.
Sir,
They are written by the same minister, written to the same company. So this is to say, continue mine in the 5 concessions. I'm giving you that opportunity, and we are reorganizing ourselves so that we conclude negotiations.
And you will agree that that message would never have been delivered if, in fact, as of September 2012, the ministry had made the decision to reject the 2010 application for 3 of the concessions, correct?
I didn't get your question, sorry.
The message that you just stated, NRD was to understand that it was being given the opportunity to continue mining at all 5 concessions while the discussions continued, would never have been sent if in fact what the minister meant was you're rejected and you cannot pursue a license for 3 of those concessions, right?
I think, sir, it's not appropriate for me to make a further interpretation of this very clear letter. It is in the same context with the previous letters. This is a process that was ongoing. The government was telling NRD, come to the table so that we negotiate. So I think I'm not able to make further interpretation on this letter.
It is not just negotiate any topic, sir. You keep saying a very general term. That the letter says specifically negotiating contracts, right?
You are right.
And the contracts that everybody was talking about in these letters are licenses, 1 or more licenses for 1 or more concessions, correct?
You're right.
You will agree that it would be completely inappropriate if the ministry already made an internal decision to reject the November 2010 application for 3 concessions so that NRD was not approved to operate those going forward, to leave it nevertheless operating them, correct?
No, it's not correct. Excuse me. There was a meeting between NRD and people of Rwanda Natural Resources Authority. And those people were representing the ministry. They made it clear to NRD that the ministry is ready to move ahead with contracts for 2 concessions. And it was also clear in the mind of the ministry that it was for short-term license. But NRD made it clear to them that they either get the 5 or nothing. So let's not extract this fact from this context.
Sir, you do know from your discussions and review of the NRD file, as well as your review of the materials that were submitted in this case, that the claimants very much dispute Rwanda's description of what was said at a December meeting. You know it's in dispute, right?
Dear sir, I met Mr. Marshall. I discussed with him. Discussing with him is also very difficult. He has a character, but we don't have time to spend on that. But the message from the ministry has always been clear. That's what I would like to mention.
You do understand I asked you whether you already know that claimants dispute what was said at the December meeting. That's my only question to you. You know they say, we don't agree with your characterization of what we were told. Correct?
And what I'm trying to say is that I don't agree with what the claimant is telling you.
Right. And you know he doesn't agree with what you're telling me, right?
I know if he was agreeing, I wouldn't be sitting here.
Okay. So I'm just trying to focus on the letter.
I'm trying to give
Let me
this
ask you a question.
tribunal the reality, the truth. That is what I'm trying to do.
Sir, please wait for a question, because
Sorry.
I ask a question about a letter and you again argue about something that happened in a meeting, and they're not lining up. So I would like to stick with the questions and answers, and your counsel is perfectly prepared to ask you other questions. You will agree that if the minister or the ministry had reached a conclusion to reject the application for 3 concessions, it would be inappropriate under Rwandan law to leave NRD operating the concessions, right?
Sorry, I'm going to repeat my answer. This was a process that started in 2010, and the answers from the minister are clear in the letter. So I do not agree with the suggestions you are making.
Under Rwandan law, the ministry must approve the operator of a mine. If not approved by the ministry, it's illegal to operate a mine, collect the minerals, and sell them, correct?
You're right.
Can't leave, so the ministry can't agree that a mine, for example, would be operated by artisan miners, free to do what they want, with no approved operator in charge of everything, right?
Sorry, I didn't get your question.
Okay, it's illegal under Rwandan law for miners to just go mine minerals at a site, take them and sell them without working under an approved operator of the mine, approved by the ministry, right?
You're right.
So just as the ministry can't agree that miners can simply operate a mine on their own, the ministry can't agree that someone it's rejected as an operator is left in charge and nevertheless operating the mine, right?
Sorry, I didn't get the question properly.
If an operator asks for approval of the ministry to operate a mine at a particular concession area and is told no, it would be illegal for that operator to nevertheless do it and operate that concession, right?
Under the law, you are only allowed to mine if you have the permit or the license from the ministry. And you can continue to do so until you get the final notice that you should vacate, or yourself, you can relinquish on your own decision and say, I'm no longer interested in this, I'm quitting.
And if the ministry says, no, we don't agree that you can operate, you're not going to be given a license or permission to operate that mine, it can't nevertheless say, but go ahead and do it anyway for a while, we'll get back to you, right?
Yes, when you are in a process of evaluation, negotiation, you can be given extensions as the case that has been granted to NRD.
Up until this point, whether it's being extended again, you say that they're in discussions, but you've also said that the ministry knows and NRD is supposed to know they're not in discussions and there's no possibility of getting licenses to operate 3 concessions. You said both, right?
If I remember properly what I said, this was a process. NRD was given the opportunity to apply for 2 concessions, and the ministry was extending the license to give NRD that opportunity. So this is what I remember I said.
But let's put specifics on that. What you're saying is the minister has told NRD, we will give you an opportunity to negotiate with us for contracts to license 2 mining facilities. We will not give you an opportunity to negotiate licenses for these 3. And you're saying it's told NRD, but operate all 5.
Yes, as we are concluding the negotiations, continue operate the 5.
And you'll agree that's entirely inconsistent with Rwandan law. If they've already been told no, if that's what the minister believes, they've been told no, we will not consider you for a license for 3 facilities. The minister then can't say, but operate them.
I totally disagree with your suggestion. Can I explain?
If you need to answer the question.
The ministry.
I would welcome an explanation, please, because I'm puzzled about this.
This company was given 5 concessions in 2006. That was in the context of privatization. The government was attracting investors. But in 2010, the government noticed that the ability of this company is not sufficient to operate 5 concessions. This was notified to NRD. But in that period of time, while the government was expecting to conclude an agreement, the government allowed them to continue mine in the 5 areas so that the 2 or 1 selected and discussed among the parties will be given to NRD. Unfortunately, this process that started by my predecessor was not concluded until I was in charge, and I tried to push it, and we failed until the 2014 law came on. And I said, people, please, NRD, now there's a new law. Let's try to put things properly. We asked them to apply basing on the new requirements of the 2014 law. Unfortunately, they failed. And we told them in 2015, we cannot continue. So this is the summary of what I remember. And this is the summary of the truth, if my mission is to give the truth to this tribunal.
Well, I don't intend or desire to argue with you for no purpose, sir. You started your answer and then said you wanted to explain, but your answer was no, I was wrong. And what I heard as an explanation agreed with my question as I understood it. So I want to try to get clarity on the record here. It's your position that the minister, your predecessor minister, in informed NRD, and it's your position, NRD understood it would never be given, excuse me, too strong a statement. Let me rephrase that question. It's your position that your predecessor minister informed NRD that it would not be granted contracts to license 3 concessions as a result of the November 2010 application, and that the parties, you say, understood NRD was not qualified to get them and would not get them. Nevertheless, while discussing the terms of a contract for 2 concessions, the minister informed NRD, operate the 3 others too. That's what your testimony is, right?
My testimony is, I don't want to speculate and interpret clear letters. I just try to explain to you what I know. And that is what I will try to do.
And did my question accurately report back your explanation?
No.
Okay. Let's break it down. As of September 2012, you stated, based on the prior communications, that we have to keep in mind the meaning both of the minister and what NRD must have understood the meaning to be, you say, was that the reference to completing the ongoing work for new contracts referred to only Route Zero and Nemba concessions, and that there was no ongoing work to be completed for licenses to the 3 other concessions, correct?
These letters were sent after the expiry of the initial contract that had given 5 concessions to NRD. Now, the contract expired and the ministry concluded that the work done by NRD was not satisfactory. But the ministry said, we are giving you a chance and we don't want to lose you. Please, let's discuss on contracts for 2. But in the meantime, because you were working on the 5, keep working on the 5 as we finalize this process.
Sir, as of September 2012, when your predecessor issued this letter, is it your position that the ministry's message to NRD was that the work that was to be concluded on contracts included work on potential contracts for all 5 concessions, or no, it only included work for contracts on 2 concessions?
My position is, if NRD had made proper work in the 5 concessions, and even here with this letter of September, I think, is it September 2012, they are still allowed to continue working on the 5 concessions. If they had successfully implemented proper work on these 5 concessions and came back to the minister and say, look, by the way, in 2010, we didn't do a lot, but with this extension, this is what we did. The ministry would have considered that new work, but nothing new apart from the information that was given in 2010. Nothing tangible new came from 2010.
Well,
on the 3 other concessions.
You'll agree with me, sir, that the minister knew what came in prior to September 13, 2012. It wasn't an open question in the minister's mind at that time whether new work came in as of that time, right?
Excuse me. how can I be in the minister's mind at that time?
Well, sir, I don't agree that that's a line you've been drawing in your answers to the questions, but I'm asking you a matter of pure logic. Or if you're going to go expand on logic, you know the minister's practice and you know how the NRD file was maintained because you picked it up. Is there any reason you can't say that as of September 13, 2012, the ministry at least knew what additional information, if any, NRD gave about the other 3 concessions beyond Route Zero and Nemba?
Sorry, I will keep repeating myself. The ministry got a report, assessed it, gave its finding to NRD. And between 2010 up to 2012, nothing tangible came to describe that there's much work that has been done on the 3 other concessions rather than Nemba and Route Zero.
Please pause there. As of September 13, 2012, your predecessor minister knew that, right?
Can you ask the question, please, again?
What you just said occurred. As of September 13, 2012, your predecessor minister knew that too, right?
You're asking if he knew what I'm telling you?
Yes. You just described what happened between November 2010 and September 2012. You characterized what happened.
Yes.
My question is simple. The minister at the time knew the same thing, right?
I didn't get your that question. Same vein, what is the meaning of same vein?
It's pronounced the word. Sometimes I talk too fast and I know that, but I have a hard time slowing myself down. What you just described as occurring between the application in November 2010 and the state of affairs in September 2012, your predecessor minister knew the same thing, right?
Yes.
Okay, so just sticking with that, when he sent the letter out on September 13, 2012, knowing what you've characterized as happening up until that date, is it your position that when he referred to new contracts that will be negotiated going forward after, from that date forward to be negotiated, he was referring in NRD's case to only contracts for Route Zero and Nemba, or he was also referring to the possibility of contracts for the other 3 concessions too? Which?
Oh, so sorry, the question was too long, and I got lost, unfortunately.
I can be criticized for lots of things, and I'll take it. Many things I do could be criticized. I'll try again, and I'm apologizing. I'm not trying to belabor this for you. I'm trying to make it simple, but I'm doing a poor job. We've already agreed that your characterization of what happened between November 2010's application and September 2012's letter, the prior minister was aware of it. With that as an agreed fact.
Yes.
When your predecessor sent the September 13, 2012 letter and referred to new contracts that will be negotiated, was he referring to new contracts for the Route Zero and Nemba concessions only, or all 5 concessions?
So let me explain it as much as I can. The position of the ministry was to offer negotiation for contracts for 2 concessions at that time. But I would guess that if NRD had come with more information on the proper work made on the 5 concessions,
Please
they would
don't
have been.
add a hypothetical. Please don't add a hypothetical and change my question before you answer my question.
That's an entirely unfair interruption of the witness. He's giving an answer to the question. If he could answer the question, because it was exactly on the question asked.
He says, if something different had happened, I've asked him to stick only with what actually happened as of the date that the.
That again is unfair. He's explaining what the ministry's point of view would have been at the point, which is exactly what he's been asked to speculate on.
Well, Mr. President, I'm going to have to ask, I do not think it is fair after all these efforts to get an answer to the question, that the answer becomes a changed question.
I'm sorry. My view is that he was answering the question perfectly clearly. And it wasn't an answer, a question that he felt could be answered yes or no.
My apologies.
He was explaining why it couldn't be answered yes or no, and what he thought the ministers meant by this offer.
Thank you, sir, for the clarification. And what I'm trying to explain, these are things that happened some years ago. You are showing me a letter which was signed by my predecessor, and you are asking me to interpret it. I cannot interpret it in just yes or no. I'm trying to give you the context. And unfortunately, my answers will seem repeating themselves because what I'm telling you, those are the facts, and you have the letters here. So if NRD had produced proper work in all the 5 concessions, the government would have been very happy to give them all the 5 concessions. But in the view of the government at this time, we were saying, let's proceed with 1 or 2. That is what I was trying to answer.
I'm going to preface this question by saying, I'm not asking you to talk about NRD specifically. I'm asking you a question of how the minister, the ministry applies its authority under Rwandan law. If a concession is held out for applications, an applicant applies for, as part of the tender, for the license to that concession, the ministry decides you do not qualify, you will not be given a license. Do you agree with me, sir, that it would be inappropriate under Rwandan law to say, but for the time being, operate the concession anyway?
I do not agree with your interpretation of the facts.
I specifically said I'm not talking about NRD, so please don't talk about NRD in the answer. I'm asking a hypothetical question about how it works, how the ministry's authority is applied and what they can and can't do. So please don't answer about what it did with NRD. Answer only what I'm asking. If somebody applies, makes an application for under a tender, which has nothing to do with our case, for a mining concession, and the ministry says, no, you do not qualify, you will not be given a license. Do you agree with me that it would be inappropriate under Rwandan law for the ministry to say, despite that decision, operate that mine for a while?
I do not agree with your interpretation of the facts. If I'm given a minute, I can explain. You want to understand the context in which the ministry operated. The first thing is to get a license. When you get a license, you operate. When you submit an application file, the application file is processed. This can take some months, it can even take some years. And as long as no final decision has been made on your case, you are allowed to continue to operate. This is how we operated.
Sir, looking back at C-45, do you see that the date of the letter extending the license period for NRD to operate the mining concessions is from the September 13 date when it goes out to October 2012?
Yes,
2 more weeks left in the month, correct?
yes,
You'll agree that it was the only reasonable understanding NRD would have after receiving this letter is the minister believes they are so close they can complete whatever contracts he's referring to in the next 2 weeks.
I do not agree with your interpretation.
Did the minister, based on your understanding of events, your review of the file, did the minister have any reason to extend further for the remaining 2 weeks in September the licenses under which NRD had been operating the concessions for only 2 weeks, but because he was going to, something else was planned for the weeks following?
I'm sure the minister had very good reasons.
And I'm asking you based on your review, because he's not here, you reviewed the file, you looked into the facts. What did you understand the reasons were for the minister to extend it for only 2 more weeks at that time?
My understanding is that the minister was again giving chance to the negotiation process. That is my understanding. It was to give a chance to see if an agreement can be reached.
If contracts for licenses of 1 or more mining concessions could be reached, right?
That's my understanding.
And there wasn't an expectation of the minister to do something more than that in the next 2 weeks, correct?
I would not like to speculate.
Can I ask that C-160 be brought up? I am remembering to say this time, sir. Tell me when you're ready to answer a question.
Yes. Yes, I have finished.
C-160 is a January 21, 2013 letter from then Minister Kamanzi to the Rwanda Development Board, correct?
Correct.
And in the letter, he asks the RDB to initiate negotiations with the above company, which is NRD. Its initial license for 4 years expired some time back. The company has been operating on short-term extensions as we wait for the conclusion of the new type of agreement with them, if any. Do you see that?
I see that.
Now, the reason Minister Kamanzi asked the RDB to initiate those negotiations is because at some point in the intervening period between the letters in which he said to NRD, we will negotiate the contract, and this letter, a policy decision had been made that the RDB would handle the primary role in such negotiations, right?
You're right.
In the middle paragraph, Minister then Minister Kamanzi identifies the 5 concessions and says those were too many for one license. The way forward should be to negotiate a license for each concession so that they may be evaluated separately. And then he reports that activities have been temporarily stopped in 2 of the concessions because of environmental degradation. Do you see that?
I see that.
He says, however, negotiations should begin with concessions that currently have no serious issues. Correct?
Correct.
Your understanding that Minister Kamanzi was telling the RDB that other than Route Zero and Sabaya, there's no serious issue with negotiating license contracts for NRD to operate all the other mining concessions.
I don't agree with the way you are summarizing the understanding from this letter. If I may explain, this is in the same context with what we were discussing previously. Here, the minister is telling RDB, please start negotiations, but negotiate each concession separately. And I think immediately after this letter, RDB invited NRD to come and negotiate, starting with NEMBA. So this is in the same context, it's the continuation of a process.
And again, I have to apologize. I don't understand the disagreement with my answer. It seems to me your explanation was, yes, your question was correct, but you started by saying, no, I wasn't correct. You understood, just as I asked, that Minister Kamanzi was informing RDB that there were no serious issues for stopping negotiation of license contracts regarding all the concessions other than Route Zero in Sabaya in this letter, right?
You are right.
Now, prior to January 22nd, 2013, if not that day itself, when was the policy change implemented such that the ministry was to hand off the primary role in negotiating with applicants to RDB? When did that policy change and go into that led to this letter?
I don't remember the exact date right at the moment. I don't remember the exact date, but it was around that time.
Now, the first paragraph, which we started with, if I could ask you to look back at that, that included the statement that the company has been operating on short-term extensions as we wait for the conclusion of the new type of agreement with them, if any.
Yes, I see that.
But you know that as of January 22nd, 2013, there had not been a short-term extension of the licenses for any of the 5 concessions since October 2012, right?
Let me explain it again. I said that in Rwanda at that time, when you have a license, you continue operating it until a final decision has been made on your application. So no final application had been made until January 2013.
You said no final application. Did you mean no final decision?
No final decision. Excuse me. No final decision.
Right, but I was asking about something very different. I was asking about the representation in this letter that the company has been operating on short-term extensions. We looked at the references to extensions in a couple of letters that the last one said ran through the end of September 2012 to October 2012. So as of October 2012, there's no written further extension of any licenses that we've looked at so far. Do you agree that there were no written further extensions of the licenses at all?
Exactly. It confirms what I was trying to explain. As long as the ministry has not made a final decision on your application, you are allowed to continue operating. And actually here, the minister is recognizing that NRD has been operating.
I do not understand the answer. So please explain, was as of January 22, 2013, is it your understanding that NRD was at that time currently operating on a short-term extension of its licenses for all 5 concessions?
Yes, that is my understanding.
And what extended the license for the concessions to NRD from October 1 to January 22, 2013?
What extended it is the fact that no letter was sent to NRD telling them, please close your bags and relinquish the concession.
So as you understood it, there was no need to inform NRD that its licenses were extended for a period. You understood that its licenses were automatically extended under Rwandan law until it was told the opposite. You now must stop operating.
You are right.
So then why did the minister send any of the prior letters saying that it was willing to extend for a specific period of time?
The minister was showing NRD that the application has been received. Some observations had been made on the application. Some negotiations had started. And the minister said, now let me hand over to RDB so that RDB can lead the negotiation process. So I think, again, that's why I'm not willing to speculate that the fact that no further extension letter was sent is because the minister was waiting for the conclusions of these negotiations on the side of RDB. But again, excuse me, I don't want to speculate.
Wasn't the minister always waiting for the conclusion of negotiations of a contract? Every time he sent a letter saying we will extend for a short period of time your licenses?
Here, NRD had been given an opportunity to negotiate for 2 concessions, but on several occasions, they were not willing to take that opportunity. So the minister said, let me hand that file or process to RDB to lead it. So that's what is the letter telling us.
Are you aware of any communication from the Ministry of Mines to RDB, whether before or after the exhibit we're looking at on January 22nd, 2013, in which RDB was informed that there was only 2 concessions for which contracts would be considered and therefore should only be negotiated?
I wouldn't like to speculate on that.
Just asking you simply, in your review of the file and your preparations when you took it over, and again in your preparations for this witness statement that you provided in this case, have you become aware of any communication that's in which the ministry, anybody on behalf of the ministry, informed RDB when going forward with negotiations as asked with our NRD, there's only 2 concessions in which negotiations should occur because there's only 2 concessions for which contracts will be issued? If at all.
I wouldn't like to speculate.
So it would be speculation as to whether you've seen it or not?
It will be speculation if I tell you things for which I don't have facts.
Okay, so can you at least agree with me, based on your review of the file, you haven't seen anything, so you can't say that it didn't happen, but you know that you haven't seen it happening?
I do not agree with you.
If we could bring up C-54. C-54 is a transmittal letter referring to an amended application for a long-term license, or long-term licenses, correct?
Excuse me, can I be given a minute to read it?
Of course, like I said, I do not mean to imply by asking you a question that you can't read what you're being shown. I try to remember to tell you could read, but please just take the time to read.
Yes, I read it.
Now, the representatives of the ministry asked NRD to send a new document referencing a long-term license so that the new negotiators, RDB, would have it in the file when they meet with you and talk about contracts going forward. That's why this document was sent, correct?
Excuse me, can you show me where the representatives of the ministry asked NRD to do so?
It's not in writing, so no, I'm not prepared to show it to you. I'm asking you, you're aware of it in any event. You're aware that this was requested of NRD to put in the file that was being sent to RDB for negotiations, so that there was a document that said long-term license, right?
No, I do not know who requested NRD to do so. That's why I was asking you to please show me the letter or instruction that was given to NRD.
Well, you will agree that in communicating to the RDB in January 2013, the minister said, please commence now negotiations. He did not say, don't commence now negotiations because a new application has to come in first, right?
Yeah, the minister instructed RDB to lead the negotiation process. But my question was thus, where is the proof?
Sir, please just focus on my questions. When he sent the letter saying commence negotiations now, he knew that this hadn't been received, correct?
I don't want to confirm things while no document had been shown to me.
Sure, you've seen the documents. You saw, and I'll pull them up again. You saw the January 13, 2013 letter to RDB from Minister Kamanzi, right?
Sorry, maybe it's me who got it not right, but you started your question saying that the ministry requested this document. So I was just asking, where is the
I asked
letter
a different question.
requesting?
Please focus on the question I'm asking. I understand the point you made about a prior question, but we've now progressed. Please leave
Okay.
that question and listen to the next question.
Good.
When the minister wrote to RDB saying commence negotiations, you know this letter hadn't come in yet, right?
Can you ask your question again, please?
Can we put up side by side the C-160 along with this letter? Mr. Mena, you understand that when then Minister Kamanzi wrote on January 22 to RDB that it should commence negotiations, a January 30 letter wasn't yet in the file. You know that, right?
What I see is that there's a letter that was given on the 21st January to RDB requesting them to start negotiations one concession by one concession. And I'm seeing another letter applying for long-term mining license. That is what I see.
And you simply will not agree with me that the first letter you see is dated before the second letter you see. We can't get that agreement before we move on and complete the questioning?
The letter to RDB was made before the letter from NRD.
So we can agree that the minister's position at the time was we're prepared to have you negotiate contracts with NRD, knowing that he didn't have in hand any new or amended application, right?
The minister's position, sorry, it's very clear in his letter to RDB. And the minister had been through that process since 2010.
I'm not sure how that answers the question. Please, sir, focus on the question. He knew when he said, we're ready for you to commence negotiations with NRD. He was not holding an amended application when he said it, right?
I do not agree.
He knew when he said in 2012 to NRD that we'd like to conclude in one letter as soon as possible, and the other letter that we're going to conclude in the next 2 weeks. Negotiations of a contract. It was not a contract based on an amended application because he didn't have one, right?
I do not agree. Can I explain?
If it's actually necessary to answer the question, explain, sir. Just answer the question.
I think it's necessary because between 2010 until 2013, there had been discussions between RNRA, the ministry, and NRD. So there had been progress made in that process. So that is my explanation I wanted to add.
What discussions about a new amended application are you referring to?
Excuse me, I just said that between 2010 and 2013, the ministry had been already meeting with NRD and discussing on the application made in 2010.
Right. Again, I'm perplexed as how this explanation relates to my question. I simply said the minister made his statements about first the ministry being prepared to conclude negotiations of a contract directly with NRD, and then saying, RDB, we're prepared to have you negotiate these contracts with NRD. He made those three statements knowing he didn't have an amended application. He was only holding an original November 2010 application.
Excuse me, I wouldn't like to speculate. I think I tried to explain what I recall.
Okay. If I could ask you to look at, if I could ask FTI to bring up C60. Sorry, I'm trying to bring it up myself. This is your first communication with NRD, correct?
Correct.
And you invited NRD's Mr. Marshall to a discussion with the ministry on October 29, 2013, correct?
Correct.
Now, between, and I'll bring it up again if we need to for the dates, if we can't just agree we remember the dates. Between January 22nd, 2013, when your predecessor, Mr. Kamanzi, instructed the RDB that they should commence negotiations with NRD about contracts. And this letter, did anybody contact NRD, either anybody from RDB or anybody from the ministry, to negotiate?
NRD was invited to negotiate by the CEO of RDB. NRD came, there was a meeting, they discussed about negotiating for NEMBA concession. RDB was clear that government is proposing a 5 years license. NRD was not happy with that proposal. And then the process of negotiating did not yield tangible results.
Well, before I get back to the last part, excuse me, can you tell me when that meeting occurred as you understood it?
I don't remember the exact date, but it was after Minister Kamanzi wrote to the CEO of RDB, the letter you were showing me. After that letter, the CEO of RDB invited NRD to come and discuss. So there was a meeting, but unfortunately, that meeting didn't produce any tangible outcome.
Okay, I could bring up the document in one moment. I'm looking for the number to place it in time. So I'll just return to that in a second. But for the purposes of my questions, the date it occurred is not important to the next question. Following this meeting that you stated what you believe you understand happened at the meeting. Are you saying that it's your understanding that that RDB continued negotiations with NRD about potential contracts that were not successful? Or are you saying, as a result of what you described as occurring at the meeting, the negotiations were unsuccessful and that's all that happened?
I was aware that the negotiations were not progressing. And since I had become the new minister in charge of mining, Minister of State, I invited NRD to come and discuss. And as you will see, RDB is informed about this meeting. So we were informed already by RDB that the project is not progressing.
I'd just like to stop you because I don't want to get ahead to other discussions. I just wanted to be clear. What you were saying occurred before your discussion. And let me place it in time. It'll be easier. I apologize for not having this hand here. Bring up C159, please. Can just enlarge the, well, let the witness read the whole first page and let me know, sir, if you need to read more to know what this document is, if there is more.
Yes, you can proceed. Next page, if there's any.
So if it helps in your review of the letter, my only question to you is regarding the placement in time of discussions. I do not intend to ask you anything about the actual contents of the document. That's why I wasn't prepared to bring it up originally. But you said you didn't know the date. I'm just trying to orient you. So by all means, read what you need to feel comfortable to answer, but I'm prefacing my questions only about the date.
So excuse me, these events happened some time back. So that's why I was taking some time to read. And
Understood, but I'm not asking you about what was said at a meeting. The claimant's already testified that he disputes characterizations of what happened at the meeting. We're not asking you to get into it. You weren't there. I'm just suggesting to you that a document was pointed out to me that you couldn't say the date of the meeting with RDB. I wanted you to see a document that put a date on a meeting. Now, do you recall when you testified already that you know RDB's CEO invited NRD to a meeting? That occurred in May, correct?
Yes, that's what I see.
Okay. Now, after the May meeting, is it your testimony that you're aware of other communications that you're characterizing as negotiations between RDB and NRD? Or I'm trying to confirm is, are you just saying there was a meeting, the meeting was unsuccessful?
You're right. That's what I was trying to say.
The
There
latter.
was a meeting. Can I explain?
Yeah, I'm just trying to move on quickly. I apologize, but I'm trying to move faster. It's the latter. There was one meeting, the meeting was unsuccessful. That's all you were trying to say, correct?
And excuse me, because this is a complex issue. So I cannot just say yes or no. It may end up not giving the truth. to
Please,
this
sir, but I'm
tribunal.
not asking you the contents or what you think are the contents of any communications. I'm just asking you if you're suggesting there were more communications than the meeting. I'll follow up with questions if I have them.
So what I was trying to say, there was a meeting and we have the minutes of that meeting. There might have been other communications that I don't know, and I don't want to speculate on that, but at least there has been a meeting.
Thank you. Now, between the time when RDB convened a meeting with NRD and your letter inviting RDB to meet with you on October 16, did you have discussions with RDB about who would lead negotiations going forward?
The policy of the government remained the same. RDB was to lead negotiations.
And was there any written communications about your extending an invitation despite that policy and explaining why?
Sorry, the line got cut off for a second. I didn't hear the entire question.
Yeah, what was there a written communication between you and RDB about your going forward to set up a meeting despite that policy staying in effect?
I don't think there's a written communication.
You understood it at this time, RDB, sorry, I said the wrong term. You understood at this time that NRD was still operating all 5 concessions, correct?
That's my understanding.
And you did not instruct them to stop operating any concessions prior to this invitation for a meeting, right?
You're right.
I could ask that C64 be brought up. Let me know when you're prepared to answer a question about this document, sir.
Yes, I read it.
C64 is a August 14, 2014 letter from you to NRD explaining that our NRD needed to submit a new application for concessions, correct?
Correct.
Now, prior to this letter, NRD had only been informed that negotiations for a contract or one or more contracts were to occur, in the context being at the times of those letters and communications, that the only application pending was the November 2010 application, correct?
Not correct, because prior to my letter, there had been that 2010 application and another application that was sent in 2013
Okay, so
by
let
NRD.
me break the question down. Some of the communications NRD received that we've already gone over said that there were to be negotiations of one or more contracts for licenses at a time when the only application was the November 2010 application, right?
You are right.
And then in 2013, NRD was informed that it was invited to come and negotiate about a contract, again, for one or more licenses, but to negotiate a contract with RDB when there were two documents on the table, the November 10, 2010 application and the January 30, 2013 amendment, right?
You are right.
Now, do you agree with me that based on your understanding of these communications that preceded you, you're summarizing communications that preceded you even in C64, you're not aware of any communication to NRD that said, now that we have this January 30, 2013 amendment document, we're no longer prepared to negotiate one or more contracts with you because we don't consider you as qualifying for even one license. Correct?
I do not agree with you. Can I explain?
Well, first, please just tell me the date or the nature of the communication, and then I'll try to bring it up so we could follow your explanation.
I think he should be allowed to explain his answer to the question.
The answer to the question was he didn't agree with me that there was no communication. I'm asking him before he goes off with an explanation, tell me the date of the communication so we could all look at it while he explains. That's
Doesn't follow that there's anything we can look at, Mr. Cowley. Could the witness please give the explanation to his answer, and then that may lead on to a further question.
certainly if that's how the tribunal wishes to proceed, certainly.
So after January 2013, when NRD submitted its updated application file, I met with them. But there were other meetings between RDB. For example, the May 2013 meeting between RDB and people from the ministry were present. But again, there was a meeting I had with them. I don't remember the exact date, but it was after the RDB meeting, and it was before this C064 letter. So I met personally with NRD, and I again explained to them that the government is open for negotiations. However, that there are conditions that needs to be fulfilled, but we are ready to move forward with negotiations. At that time, if I recall it properly, Mr. Marshall said that for them, the only interesting thing is a long-term license for the 5 concessions. I think I told him that anything that will be agreed upon, we need to be fulfilling the requirements of the law. So there have been communications between the ministry, RDB, and NRD between January 2013 and NRD, and this letter.
In order for me to understand your explanation, I do return to the question, can you put dates on these? You met with Mr. Marshall when?
So if I had been allowed to come in with my witness statement, I would have read it and give you a date, but I was told it's not allowed, so I can't give you an exact date.
Was it before the May 2013 meeting that RDB held with
It
NRD?
was after the RDB meeting.
Was it one meeting or more than one meeting that you're referring to with Mr. Marshall?
At least what I remember properly is that I invited them and you showed me my invitation letter. So they replied to that invitation and we met. So the date, I don't remember that, but it's after my invitation.
I'm a little bit confused because I thought this line of questions had to do with what I thought I started by asking you and whether NRD had been informed of something between the dates of prior communications and this invitation letter. So I understand that a meeting occurred after your invitation, but I intended to, and maybe my confusion is caused by the fact that I think I said something that I didn't, and I apologize if that's the case. But I'd like to return to my original point. Prior to your invitation to meet, for NRD to come in and meet, your invitation that went out in August 2014, are you aware of any communication by either RDB or anyone at Minarea to NRD saying we are no longer prepared to negotiate a contract for a license with you because we've received this January 30 amendment?
Excuse me, I got confused in your question. You mentioned my invitation of August 2014. Which invitation is that? August 2014, my invitation.
I believe it's, I have a hard time, I'm sorry, I don't want to look away from you and while I'm talking, but I believe it's the document that's up, C64. I could check it in another version that I have up that's got much bigger writing for me.
So if I can help, this is not my invitation letter to NRD. It was, this letter was informing them on the changes of the law and requesting them to submit a re-application.
Fair enough, I misspoke. Then, and perhaps that was the original cause of the confusion. Between the times that starting in 2012, including in 2013, the invitation to meet with RDB, between the times that NRD was informed that RDB, or before it, the ministry, was prepared to negotiate the conclusion of a contract for a license for one or more concessions. And this August 2014 letter from you, are you aware of any communication to NRD that informed them Minarea was not willing to negotiate at that time a contract for a license for one or more concessions because it received the January 30, 2013 amendment?
So, sorry, actually, that is what I explained before this letter of 2014 and after the January 2013 application. You, if I got it properly, you're asking if there has been communication to NRD. And I said yes.
I said a specific message, sir. I'm not asking you to repeat any and all communications in the time period. I said specifically, was NRD informed that the ministry was no longer willing to negotiate a contract for a license to one or more concessions because of the January 2013 amendment?
I will not, you are phrasing it as a something short, but the ministry informed NRD that it is not prepared to grant the 30 years license after the application for 30 years.
But that's a term of a contract, sir. I've asked a very different question. I've tried to focus and leave my question at the same level that the communications that went to NRD that we've spoken about now numerous times. Negotiating or concluding a contract for a license. You specified your understanding that only referred to 2 concessions. Had anybody before your August 2014 letter said to NRD, we're no longer in a position of negotiating a license for any concession because of the January 2013 amendment? It's a very specific question.
It's a specific and complex question. If I got it, okay, I met them, but then your question is confusing me. Did I inform them that the ministry received their long-term application? Yes. Did I inform them that you are not going?
Please allow the witness to continue.
So did I inform them that we are not able to grant the 30 years because they were now applying for 30 years? Did I inform them that you are not ready to grant the 30 years license? Yes. That's what I can answer.
But my question goes further than that. Are you aware, yes or no, whether anyone, RDB, you, or anyone else on behalf of Minarea, informed NRD you weren't prepared to negotiate a contract for a license, whatever its terms may turn out to be, for 1 or more concessions because of the January 2013 amendment?
Yes, I informed NRD that we are ready to negotiate with them.
Just to be clear, because I think your answer was, and I don't want the record to be confusing. I thank you for the answer, but I think you said yes when I asked the opposite. You did inform. You did inform, even after January 2013's amendment. You informed NRD you were willing to negotiate a contract.
Yes, I informed. Yes, I informed NRD that we were willing to negotiate with them.
For a contract for a license is the question.
A contract for?
A license to 1 or more concessions. I didn't specify any particular terms, just a license. Were you willing to negotiate a contract for a license?
You are right.
Thank you. Now, prior to this letter from you that's been marked C-64, was there any discussion that you're aware of, any communication that you're aware of to NRD informing them that before any further discussions about a contract for a license could go forward, a whole new application had to be submitted?
So let me explain it, giving the context. I met with NRD. I told them that we are willing to negotiate with them a license or a contract. They told me that they want 5 concessions. I told them if there would be any concession, it should be negotiated separately. We put together a team at the ministry that will help in that process. Unfortunately, NRD didn't come on board to continue the process until we reached 2014.
The discussion that you said you just had at a meeting with NRD, was that before or after the letter we're looking at?
It is before this letter.
And you say the date is in your witness statement?
I believe so.
Well, I'll take a look at the break and I'll try to come back just so we put clarity on the record. I don't have that reference handy.
It's paragraph 25.
Thank you. Second witness statement. So the supplemental witness statement, paragraph 25, if that could be brought up, please.
No, the first witness statement.
Well, then we found it twice. So can I have the supplemental witness statement brought up at paragraph 27? 25 or 27? Second supplemental, or actually the supplemental. Actually, I don't see the title. Is this the supplemental?
This is the one I was guiding you to. It's obviously you must take your own course. This is the one
I don't
guided
have
you.
it in
It's the
front of
first
me.
witness
I
statement.
can't see it. That's my only problem. I was trying to bring up the one that I could see. But if the date helps you, sir, I actually am trying to speed things up despite failing miserably at that and slowing it down. I'm trying to speed things up. So please, if we're in the document that it's paragraph 25, bring up paragraph 25 for him and let him look at it. I'm sorry, supplemental's up 27.
That's it.
It'll be enlarged, sir.
Yes, I read it.
So is the reference to the meeting in that paragraph, the meeting that you were just testifying about?
Exactly.
And the meeting occurred October 30, 2013?
Exactly.
And that's after the letter that we were looking at?
No,
As
before.
C-64?
It's before.
Sorry, it's before because this is 2014. I apologize. So prior to this letter in C-64, you had informed NRD in October 2013 that as you testified that they needed to apply one at a time, correct?
I can repeat again what is written.
Just focus on one term at a time, please. You testified about a meeting in which you instructed Mr. Marshall. Your position was it needed to be one concession at a time, correct?
Sorry, it's not as you are trying to put it. If I can explain, in this meeting, I told them that first, they no longer have licenses. Although we know they are operating, they don't have licenses. And the priority to us was to help them get licenses. Two, I told them that the ministry was willing to continue the process started by my predecessor and negotiate one or two concessions. Unfortunately, Mr. Marshall was not willing to accept our offer. The other part you are mentioning of applying one at a time comes in 2014 after this meeting.
Okay, sir, when you told Mr. Marshall in this meeting in October 2013 that they no longer had licenses, was that the first time that you contend NRD was informed of that?
NRD knew that they had no license since the last extension given by Minister Kamanzi, but we still allowed them to operate. And now we wanted to regularize that situation.
Sir,
It's time for a break, I think. 30-minute break. I'm getting very concerned about the time when I look at the original timetable.
I'll work
Better
during
think
the
about
break. I'll work during the break to make sure I narrow as much as possible.
Right, 30 minutes.
Okay, we'll go ahead and open up the breakout rooms. Okay, Mr. President, the witness is in the waiting room, ready to come in upon your request.
Could I just raise one point which relates to my two next witnesses? I've got both of them on standby. If Mr. Cowley is not going to get on to one or both of them, could they be told now so they could go? Because I'm sure they've both got commutes and it's getting late in the Rwandan day.
So Mr. Guattari, I think could be asked to leave, even if we're short, and I have lower estimates of time with Dr. Michael than originally. I do believe will be faster than originally anticipated, but nevertheless, even if we weren't originally intending to go into tomorrow with Dr. Guattari, I do believe I've reduced that as well and can reduce the expert witness's time compared to what was originally anticipated. So I am not anticipating a timing problem as we currently stand that will continue through the day tomorrow, at least on my side.
Well, very well then. Dr. Guattari can be told he can go home. Is he a doctor?
Thank you. He's a Mr., I think. Thank you.
Yeah, Mr. Guattari.
Thank you, Mr. President.
All right. Would you like the witness now?
Yes, please.
Bringing him in.
Mr. Amena, on August 14, 2014, and if it could be brought back up just so he has it available if necessary, C-64, when you sent your letter to NRD that we were looking at before the break, you knew the circumstances NRD was actually facing on the ground with regard to access to its offices and the concessions, correct?
No.
You were informed that Mr. Benzingi was claiming to have ownership rights in NRD, and he was taking action to prevent Mr. Marshall from operating the company, correct?
Not correct. I knew Mr. Benzinge was having claims regarding the ownership of NRD. I didn't know at that time that NRD had issues in accessing its office.
Well, we'll get to it in a moment in terms of your witness statement. So if you need to read it before you can answer any questions, just tell me that and I'll wait for any questions about it. But you do recall Mr. Benzingi approaching you to explain his position and what he wanted to see done. And that factored into your decision about whether or not to permit NRD tags to be provided to the company, correct?
Not correct.
Okay, we'll get there. Let me focus just on the August 14 time period. So it's your testimony that when you sent the letter that's up on the screen, C-64, that you had no idea Mr. Marshall and Ms. Zuzana were put out of access to the corporate offices and the NEMBA offices. That's your testimony?
Yes.
You knew, even though you didn't know that fact, it was an assumption on your part that in order to prepare and complete a new application that would be consistent with the 2014 law, whoever was in charge of preparing it would need access to all the corporate information about activities over the years since at least 2010, right?
No, let me explain it. What I knew is that we sent this letter to NRD when I was not informed that they don't have access to their office. Then the second thing I know is that to prepare this type of application, you need information that you may have in your office, that you may have in your computer, and that you need to collect from other government offices.
And it was your assumption that they had access to all of those things at your testimony when you sent this letter out?
Yes, when I sent it, I thought they had access to all the necessary information.
When did you learn that they didn't?
Can you please repeat?
When did you learn that they did not?
When Marshall wrote to me and informed me that they don't have access to their office.
And when he wrote to you and told you that, did you then respond, well, then you don't need to worry about trying to prepare and submit a new application until that's corrected?
I gave him another chance to collect and submit all the information.
What do you mean another chance?
He was given a letter by myself, by the ministry, extending the period of time he had been given.
And is that because you recognized that the first period of time went by and it really wasn't a chance to respond to the request by filing a new application, since access to the offices, the computer, the information in the files wasn't available?
No. Can I explain?
Please.
Mr. Marshall was given this letter we are seeing on the computer to submit an application. That application was received by the ministry. It was assessed. We found that it was not satisfactory according to the requirements. Mr. Marshall claimed that he had no access to some of his documents, but the assessment was showing that some of the critical things he failed to provide are not even documents that should be found in his office. For instance, a tax clearance certificate. He failed to provide that, and that is never found in an office, is requested from the Rwanda Revenue Authority. Again, another document was the Environment Management Authority certificate, which is also, we called it recommendation, which was to be provided by the office in charge of environment management. That was not in his office. So we thought this was a trick to continue delay the process of this licensing scheme that we had entered in with him.
So that's a reason for not extending another chance, as you called it, right? Those are all reasons to reject an argument that the first chance wasn't a good chance and say, no, we're done, right?
Not as how we are putting it. He was given here 30 days. If I remember properly, beyond the 30 days, he was again given 15 days.
And you just told me the reasons why you think he didn't deserve it, right?
And by the way, we had no legal obligations to give him an extension. But because we wanted to help him and have him as an investor, we extended to him that opportunity.
And that's the reason you extended it, because you wanted to have Mr. Marshall be an investor in one or more of these concessions.
You are right.
Now, at that time of the first request in writing for the submission of a new application went out to NRD, how many other applicants for licenses beyond an initial exploratory license phase were given similar licenses, similar requests to resubmit their application?
Several companies were requested to abide by the 2014 law.
That's not my question, though, because the 2014 law may cover a lot of things. I want to make sure we're focused on the same thing. I'm asking you, within the pool of applicants for licenses to operate mining concessions, how many such applicants in August 2014 were told, submit a new application and we'll go forward with the process of considering it?
So if I can explain it properly, NRD's case had started in 2010, continued to stall. And in 2014, we asked them to comply with the new law. All the other companies in the country were informed that we have a new law, and anyone who wants to apply for a license will need to apply fulfilling the obligations of the new law. But again, we had no legal obligation even to write this letter to NRD. But because of out of good faith, we said, let's extend to him this new chance to fulfill the new requirements. We had no obligations to do so.
So I'm going to ask you again, of
Yes, please.
the applicants seeking a license to operate a mining concession beyond the initial exploratory license period that existed as of August 2014, how many of such applicants were informed that they had to submit a new application?
I don't remember the number.
Can you identify even one?
I don't remember the number, but I can give you a case. Gatumba Mining Concession was asked to do the same, to comply with the new 2014 law, Gatumba Mining Concessions.
Can you identify any other?
I gave you just one. I don't remember the other.
That was my question. Can you remember any other? You said you can't remember the other. So
Unfortunately, I remember right now Gatumba Mining Concessions.
Okay. As of August 2014, how many applicants for licenses to operate mining concessions beyond the initial exploratory license phase existed?
Can you repeat, please? And if I'm allowed to answer, I also remember Trans-Africa and Rogi Mining. Trans-Africa and Rogi Mining, if I remember well, as cases asked to fulfill the requirements with the 2014 law.
Again, just to be clear, I'm not asking whether you told people to fulfill the requirements of the 2014 law. I'm asking a very specific question. I'm asking you to tell us who you actually recall telling as a pending applicant to submit a new application under the law. So with that clarification, Please let me know whether your answers were to that question.
Those are the examples I gave you.
Now, how many applicants for a license to operate a mining concession beyond the initial exploratory license phase existed as of August 2014?
Companies that had licenses before 2014 and that continued beyond 2014.
No, I'm asking a different question, not who had already been issued licenses. We talked about yesterday, your memory as best you could recall, how many applied, how many were awarded. I'm asking how many were pending. So of the applicants for licenses to operate a mining concession that had a pending application that was originally submitted before 2014, how many of them were told in August 2014 or by August 2014, submit a new application?
There are many, but I don't remember the number.
Can you remember whether it's more than 25?
I wouldn't like to speculate on a number.
If I could ask that C-119 be brought up. Please let me know when you're ready to answer a question.
Yes, I read it.
This letter, C-119, is an October 28, 2014 letter in which you informed NRD that its reapplication was denied and it needed to turn back over all the concessions, correct?
Correct.
And you had some details about, or you referenced a closure process. That position changed after this letter, correct?
We gave him 7 days to lodge an appeal. So he appealed to that decision. That's why we had to take into consideration his appeal.
And who was considering the appeal?
There was a committee at the ministry.
Okay, and when did they decide that appeal?
I don't remember the exact date, but it is after this October letter.
Okay, can you bring up C-87? More than one page, so if you can open it up to 2 pages, witness.
Exactly. I read it.
So after the prior letter that we just read, this letter informed NRD that it had another opportunity to submit more information, correct?
You're right.
Had the appeal been decided in between?
I remember Mr. Marshall claimed that his application was fulfilling all the requirements. Then we gave him this opportunity to go ahead and prove it again. And we again gave him a list of the documents he needs to submit.
My question was, in between the last two letters we looked at, was the appeal decided?
Exactly.
Okay, so the committee issued a decision internally?
Yes.
It's in writing?
I don't remember.
After this letter, NRD did submit more information, correct?
They submitted additional information. That information was again reassessed, and unfortunately, it was deemed unsatisfactory.
And when do you recall when you informed NRD of that position?
Yes, there's a letter definitely after this November 2014 letter.
And it's in 2015, correct?
I think so.
And that letter informing NRD of that decision in 2015 ended the same way as the prior letter we looked at, that the concessions had to be turned back over, correct?
You're right.
Turning over the concessions didn't require any sort of physical action by NRD to put something that constituted the concessions back in your office, right?
No.
It meant step out of the way so the government could take over control of the operations, correct?
No, not as you are putting it. It meant fulfilling the requirements of the law we mentioned to him in our letters. So the 2014 law was clear on what happens if an application is rejected. So he had to implement what was in the law.
Who would take over operations since NRD was denied the ability to continue operations? Who was going to operate the mines?
No one.
Can we talk a minute about what was happening at the mines as far as you knew in this time period, 2014 into 2015? One of your major complaints against the applications submitted by NRD is that mostly artisanal mining was occurring at the sites of the mining concessions, correct?
I don't remember what was going on specifically at that period of time.
You are familiar with the phrase artisanal mining, are you not?
I'm familiar with that phrase.
And you are familiar with the fact that the ministry raised as a complaint against the applications received from NRD that primarily artisanal mining was occurring at the sites, correct?
Can you show me that document where we raised that?
If the answer is you actually don't remember that being an issue, I'd rather you just tell me and I'll accept that as an answer.
Can you ask me again the question, please?
Yes. Are you aware of whether or not the ministry raised as a criticism of the application submitted by NRD that primarily artisanal mining was occurring at the concession sites?
There are several areas, including that one you are mentioning, that shows that NRD was not fulfilling the requirements.
I'm asking specifically, do you remember the issue of primarily artisanal mining occurring at the sites being raised by Rwanda? Or if you don't recall, that's your answer and I don't, then I have an answer.
I don't recall.
Okay, so again, now I am not asking then about NRD specifically because you told me you don't recall. So please just focus on the question I am going to ask. Artisanal mining, as you understand that concept, that does occur in Rwanda, is conducted by individuals that live in and around the areas covered by particular mining concessions, correct?
I didn't get your question. I'm sorry.
The artisanal miners are people that live near the concessions, near some of the concessions where such mining takes place, correct?
That's not my definition.
Okay. There are people who conduct personally mining activities at or around the concessions, correct?
Correct.
And those people go out with their own tools, their own implements to collect minerals, which they try to sell on their own, correct?
If people go in a mine without an authorization, a license, they are called illegal miners. They're not called artisanal miners.
I'm trying to, I was going to get there because you didn't have an agreement with me on the first, so I'm backing up. I didn't put that back in my question. Please just focus on the question. If people go out with their own tools and implements and take minerals as however they can, they're trying to sell them after they obtain them, correct?
Yes.
Okay, so you understand that around some of the mining concessions in Rwanda, there are individuals who do that, let's stick with illegal mining practice, because they need to do it in order to make money to live, them and their families, right?
You're right.
Now, artisanal mining is also a primarily labor-intensive individual with limited tools, manually obtaining minerals that the mining operator then collects and sells, if that's how the mining is done at their concession, right?
No, it's not as you are suggesting. If I can explain quickly. In our country, we have several miners. And according to the 2014 law, we have 3 types of mining licenses: artisanal mining, small-scale mining, and large-scale mining. So being an artisanal miner is totally different from being an illegal miner.
I recognize that. That's why I didn't mix the two in my questions. I asked about the artisanal miners when they're conducting at concessions. These are individuals that are conducting mining at the concessions primarily by hand, correct?
There is no individuals granted with a license. Licenses are given to cooperatives or to companies.
I really didn't anticipate this was going to be an argument. I'm not trying to argue with you, sir. That the miners, let's use that term. I'm switching terms. I'm not talking about the licenses afforded them. The miners who conduct the mining operations of an operator who is given an artisanal license. The miners are people that are doing it by hand at the concession, correct?
A miners, yes, is someone who is working at a mine.
And the people who do that sort of work live around the mine. They're very local to the concession, doing it by hand and then going home very close to where they're mining, correct?
Correct. Most of them live close to their mines.
So both the illegal miners and miners who are doing it legally under an artisanal license, there are people who get up every day, go into a concession and by hand extract minerals, and they try either through the operator or on their own, to sell it and make money so their family can live, correct?
They cannot sell it if they don't have the authorization to do so.
Right. Well, I'll get there in a moment, but that's what they try to do, don't they?
Can you repeat, please?
Yeah, the people who are getting up and going out every day, conducting these mining activities, they're hoping to turn the minerals into payment. Illegal miners on their own, artisanal miners from the operator, correct?
You're right. Mining is about money.
Yes. So if you say that the mining concession is not going to be operated, you actually know that the people who need the money for their families to live, and they're all around that concession, and they got up every day and mined minerals by hand, they're still going to keep doing it because they still need the money, right?
Government puts in place measures to quickly issue licenses to capable companies to manage mines or areas where minerals have been discovered.
And that would be the operator of the mine, right?
Yes, new operators will be invited to come in.
Right. So I'm going to get back to that a moment ago, because you said no one was going to operate this, and that's what caused this question. With regard to the miners themselves who are doing work every day, when you told NRD you're no longer able to operate these concessions, turn them back over, the miners still needed to get up the next day, mine minerals, and get paid for it because their families needed the money, right?
Yeah, that would be illegal mining.
Okay. So the day before they might have been artisanal miners, the day after they might be illegal miners, but they're still going to do it, right? You knew that.
Illegal people exist everywhere, and they even exist here.
So when you say that no one was intended to operate the mining concessions right away when you asked NRD to turn them over, you knew miners were going to mine the next day, regardless of who you said was operating it, right?
Those are illegal miners.
And I'm asking that whether you knew as a practical reality it was going to happen, right?
No.
Sir, when you asked NRD to turn over the concessions, you didn't think any and all mining by any and all miners was immediately going to stop because NRD was no longer permitted to call itself operator, did you?
That was not the wish of the government.
You also knew that for the government to say, here's a mine where I know people are getting up every day and mining minerals to get paid for it, but I authorize no operator to oversee that's contrary to the law, don't you?
Can you repeat, please?
For the government to allow mining at a concession with no licensed or permitted operator is contrary to the law.
Illegal mining is not allowed in Rwanda. It is punishable by the law.
So if you don't permit an operator to run a mining concession in order to comply with the law, the government would need to actually send out security and prevent illegal mining on its own every day, right?
If someone is doing illegal activities, the government deals with that person who is doing illegal activities.
And you had no real question that mining had to continue every day because the people needed to live, right?
Not right.
Sir, what did the government do to take possession of the concessions after telling NRD in 2015 it must stop operating the concessions and turn over those concessions to the government?
You asked me, what did the government do?
Yes.
The government sent teams to all the former NRD concessions. Evaluations were made, and following the new law, some of the blocks, some of the former areas were divided into blocks, and those blocks were put out for tender. And that's the document we discussed earlier today.
So it sent geological teams to assess the area and decide what concessions could profitably be put out as available for applicants to bid on?
Yes, not only geological teams, but environmentalists, economists, so a group of professionals.
But it didn't send out teams of security to keep illegal miners off the concessions and or any teams out to provide safety for anybody who might be conducting mining or other activities there, correct?
If people engaged in illegal mining, then appropriate institutions of the country dealt with that.
Just answer my question though, please. You didn't send out security teams or other safety teams to take care to prevent illegal activity or take care of the people who were there acting as miners before, correct?
Excuse me, I was not leading the police. I was leading the Ministry of State in charge of mining. So I sent geologists and other engineers.
Did you send the police to all the concessions and ask them to secure that and prevent any illegal mining and protect the safety of the former miners who lived around there?
The local authorities and all the people in charge were informed that NRD is no longer operating the mines. So all the institutions were informed and they implemented appropriate measures.
So you're familiar with the fact that NRD's head of security and other operations stayed on site, providing that security, continuing to protect the concessions as best as possible, while in 2015 and after, NRD was told it was not permitted to operate the mines, don't you?
After I sent my letter to NRD informing them that the discussions and the negotiations are over, I no longer went back and dealt with that case. And
you did not follow up with anyone from NRD to after informing them that their concessions were, their licenses, excuse me, applications for licenses were denied in 2015. You did not go back and follow up and tell them you were going to complain about the fact that they did not do any number of things that were required to turn over a concession, correct? You just stopped communicating with them and let it be, right?
Not right. After my final decision was made, I sent to NRD a letter informing them a process that will lead to the final winding up or winding down, actually, of their activities. They refused to participate to that process.
Well, based on your letter in 2015, they wouldn't have been there, would they?
Can you repeat, please?
Sending a letter to the former concessions of NRD wasn't going to reach NRD after you told them they're not allowed on the concessions anymore, right?
NRD was a registered company in Rwanda, so without a license, it doesn't mean that the company is no longer existing.
Right, but sending mail to the company concessions or offices weren't going to reach them when they were told they weren't allowed to operate the concessions, right?
I can repeat it. NRD was a company. It had an address. It had an office. It had people in charge of that company. So they were informed about that process.
If I could ask that the witness statement, the first witness statement be brought up and paragraphs 49 and 50 focused on.
Yes, please. I read it.
When you refer here to PACT, you are referring to the agency that at that time was responsible for administering the tagging system and working with the mining concession operators to do so, correct?
You're right.
And when you say in the summer of 2014, you barred them from providing the tags under the ITSE system to NRD, are you referring to before or after the letter in August in which you instructed NRD to submit a reapplication?
Can you repeat your question, please?
All right, I can make it more simply. I'm sorry. See the beginning of paragraph 49, in around the summer of 2014, I barred PACT, and you went on. The time period you're referring to there, is that before or after the letter in August 2014 in which you instructed NRD to file a reapplication?
I don't remember the exact date I informed PACT, but it was in 2014.
Wasn't it much earlier when the bailiff worked with Mr. Benzingi to seize the offices and then the NEMBA facility office?
I don't remember when their offices were seized, the exact date.
In the summer of 2014, there were, although you've already told me, I asked this question about identifying the number. You said you didn't remember the number, but can we agree that there were applicants for licenses beyond the exploratory license phase for mining concessions that had not yet been granted long-term licenses for those concessions?
Yes.
They were getting tags, right?
Yes.
They had no active license issued by the ministry at that time, correct?
Yes.
You didn't bar PACT from providing tags to any of those other applicants, did you?
They didn't have issues similar to the problems NRD was having.
Paragraph 53 be brought up, please. Do you have an opportunity to read it, sir?
Yes, I read it.
You call it a secondary issue, but one of the reasons you say you decided to bar PACT from issuing tags to NRD is Mr. Benzingi informed you of his claim that he was the rightful person to be in charge of NRD and that he in fact threatened to sue should NRD be issued tags unless he was treated as the person in charge of NRD, right?
If I can explain it, the first reason to bar NRD from accessing tags was the fact that they had no license, no valid license.
I moved
And
on
again,
to that, sir. Can we focus on the secondary issue? I just want to, I moved forward.
And the second
Thank you.
was the fact that Mr. Benzinge showed me a rule by the Supreme Court of Rwanda saying that he's the owner of NRD and telling me that if we continue engaging with Mr. Marshall as the representative of NRD, he will bring a case to court. So as a minister, someone working for the government, I take very seriously rules from the Supreme Court. Then I told him that I'm not going to be involved in his problems with NRD, but I'm not going to give him tags because he came to see me thinking that he will be the one given tags. I told him no, but I said whoever owns NRD will receive tags after their issue of license is regularized.
Okay, when Mr. Benzingi brought you a rule from the Supreme Court, did you read the decision, or did you just listen to Mr. Benzingi as to what he said the decision meant?
I think I read it.
Uh,
If I remember properly, I think I read it.
Well, you would agree it wouldn't have been reasonable for you to just rely on what Mr. Benzingi said the Supreme Court ruled without looking at it if it was going to form any part of a decision whether to allow NRD to participate in the tagging system, correct?
I think not only me as a person reading it, my advisors took a look at it and informed me that this is something that can be serious against the ministry.
And having read it and talked to your advisors about it, you knew that the order from the Supreme Court said Mr. Benzingi was a 15% shareholder, a minority shareholder in NRD, correct?
I don't remember the whole details of the ruling from the Supreme Court, but what I remember, the ruling was saying that Benzingi is the one representing NRD.
The ruling actually said it wasn't going to change the underlying arbitration decision that itself said it wasn't going to change Mr. Marshall's designation as representative, even though Mr. Benzingi insisted that he be identified as managing director. Isn't that what the rule said?
I don't remember going into details of the ruling, but I remember having been shown that ruling, which was saying that Benzingi would be considered at that time, specific time, as the representative of NRD.
You say you read that in the order.
Yes.
Did you ask for any clarification from the administration within Rwanda's government responsible for determining rightful ownership status of corporations?
I asked clarification to Benzingi and to Marshall. I said the ministry will only deal with the rightful owner of NRD as it is indicated by RDB. And Mr. Marshall was the one to come and show me that in the register of RDB, he's the rightful owner. And that's why we continued proceeding with him.
Why didn't you ask the registrar yourself?
I had the choice to either ask Marshall, Benzingi, or the register. I choose to ask those two people who were claiming to be the rightful owners.
Right, but you were familiar with the fact that the registrar was the ultimate authority on disputing parties' claims of ownership. The registrar would say who's right and who's wrong, correct?
Yes.
And you're saying that as Minister of Mines, you decided to ask the two disputing parties, but not the administrative body that's in charge of resolving their disputes.
I had no obligation to ask him.
Did you ask the Ministry of Justice, since this was a legal issue regarding what had to be done as a result of a Supreme Court decision? Did you ask the Ministry of Justice to advise you in any way?
The Minister of Justice has been advising the Minister of Mining throughout this process.
I'm sorry if I asked a poor question, but I'm just trying to refer to specifically. Did you ask the Minister of the Ministry of Justice to address the question that Benzingi raised about the Supreme Court decision so that they would answer his question?
Let me try to be specific. I didn't engage in this issue between Benzinge and Road Marshal. I just told them the rightful owner of NRD should come and prove it. And Marshall ended up proving that he's the one recognized by RDB. And that was the end of it. We proceeded with Marshall.
That took months, right?
That took
quite some time, correct?
It depended on their side because they were the ones requested to prove that.
Well, you say that, and you say that you told them you weren't going to get involved, but in fact, your witness statement admits there was a secondary reason that you gave them for not permitting the company to have tags that were required in order for the company to keep earning revenue.
It's not only that reason. I even had a verbal advice from Dr. Michael, who told me that they made also an assessment internally, and they also gave me an advice. So I considered several advices.
I'm focusing on this Benzingi issue and your witness statement's characterization of it as a secondary issue. You said you're not getting involved, but you chose a path to say, while it was one of the grounds for not issuing tags, you chose a path that didn't get quick resolution by one of the other representatives of the government capable of issuing a final determination very quickly, correct?
My mission was not to resolve the problem between Benzinge and Road Marshal. My mission was to see if NRD has a license and is operating through the law.
You understood that the refusal to allow PACT to issue tags meant that Mr. Marshall or whoever was going to prevail in the dispute about controlling NRD would essentially be financially strangled from continuing with those concessions. Because without tags, there's no legal revenue to be earned from the minerals mined at the concessions.
The primary concern for the ministry at that time was to ensure that NRD gets a license. That was the primary concern. And stopping NRD to get the tags actually yielded positive results to the ministry because NRD had been refusing to take note of all the advices given since some years back. NRD had been refusing to understand what the ministry was telling that company. And when we touched the tags, they started submitting documents that we were requiring. So stopping them accessing the tags was very positive.
Can you please explain how it is that you felt comfortable as minister to say that the entity that you continued to recognize as the operator of mining concessions, where mining was being conducted, minerals were being extracted, somebody wanted to sell them for cash, all was taking place. You were comfortable leaving in place as operator a company that, on the other hand, you were saying was not qualified to receive tags to sell those minerals?
You put it very well. The entity I was leading was recognizing NRD, but at that time, NRD had stopped to recognize the entity I was leading. And the only tool that helped them understand that the priority of things is to have a license was touching on the tag thing.
Well, you know that's not true. Even under the period where they were operating on the initial license, there's always the ability for the ministry to say, since it's a contract, there's a breach of contract, it's terminated. You knew that, right?
Not at all. I do not agree. NRD was happy continuing receiving tags because NRD was not investing. They were just buying minerals from the mine workers, selling them in Kigali, and making small profits. We were telling them, please comply with the laws. They were happy to continue operating without a license. And we just tell them enough is enough. Please come and comply.
You were familiar that you had a tool of claiming breach of contract if you believed there was a breach of contract. You knew that, correct?
Can you repeat, please?
Yes, I'm trying to follow up on your testimony where you said you only had one tool available to you. You knew, since the licenses were contracts, you always had available a tool to claim breach of contract and terminate the license of NRD. You knew that at every phase, right?
There were several tools and stopping tags was among them.
Okay. And it's the tool you chose in the summer of 2014, correct?
Correct.
And your testimony here today was in October, I believe, or at some point, I'll pull up the notes if it's important, but at some point in 2013, you met with Mr. Marshall and told him at that time, you as minister considered NRD no longer to be a licensee at the concessions, correct?
Can you repeat, please?
Your testimony here today is that in 2013, you met with Mr. Marshall, and at the time of that meeting, you told him the ministry no longer considered NRD to be the licensed operator of the mining concessions.
I don't want to get confused and to confuse this tribunal. What I know, I met Mr. Marshall several times in 2013, 2014, and even in 2015. Now, in 2014, there was this reapplication file.
My question asked you about 2013. Please just direct your answer to 2013. Isn't it your testimony here today that in a meeting in 2013, you told Mr. Marshall you did not consider NRD to be a licensee of the concessions anymore?
In 2013, during a meeting I had with them in October, I informed them that they have no license, but the ministry is engaged to discuss with them 1 or 2 licenses.
Okay.
That is what I said in 2013.
So from that October meeting, when you told that to Mr. Marshall until the summer of 2014, it was your position that NRD was no longer a licensee of the concessions, but you continued to recognize NRD as permissible to receive tags to sell minerals mined at those concessions.
Yes.
Isn't that correct?
Yes, they were still recognized as the people operating the mines.
Well, how is that? Under Rwandan law, how could they be recognized by the Minister of Mines as both not a licensee at all, but operating the mines and lawfully selling minerals mined there?
I explained earlier that as long as for a former licensee who applied for a new license, as long as no final decision has been taken, we consider that former licensee as the operator of the mine.
So the permission from the initial license to NRD, your testimony is you recognized as continuing all the way to the time where you told NRD it had to leave the mining concessions.
You are right.
And that's in 2015, correct?
That was the final decision, 2015.
Thank you. No further questions.
I have no re-examination.
I wonder if you can just give me a little bit further explanation about the artisanal miners. And perhaps if we look at paragraph 49 of your first statement, that would be a convenient way of doing this. Could that be put up? The second half of this paragraph reads, by June 2014, NRD had not had a mining license for any of its concessions since October 2012. However, with our indulgence, it was continuing to operate its mines, and you've been telling us about that. And this was an indulgence that the ministry gave to a company that meant it was not acting unlawfully in continuing to mine, notwithstanding it had no license. Is that right?
You are right, sir.
And that was what, under general administrative power, that the ministry could do that?
You are right, sir.
So I see. And you say it was continuing to operate its mine through the artisanal miners and was able to buy minerals from the artisanal miners on its site and have them tagged, following which it was able to sell them to traders in Kigali. But was the tagging being done on site or in Kigali? Because there's conflicting evidence about that.
Tagging was being done on site.
On site. And these miners, were they miners who had individual license, may be the wrong word, but concession as an artisanal miner to mine?
These miners were operating under the authority of NRD. So we are calling them artisanal miners because they were just using artisanal tools, small handheld equipments.
Well, this is what interests me. NRD is given a concession or a license to mine. There are a lot of miners living around the mine, and NRD uses them to exercise its license. Now, I could understand if NRD employed them and paid them as laborers, but this suggests that they would own the ore that they mined and sell it to NRD. And that's what I have a little difficulty understanding. How were they able lawfully to extract minerals which they owned and could sell to NRD?
Yeah. Thank you for the question. NRD was given concessions and was supposed to create industrial mines in those concessions. And for industrial mines to be developed, you need to employ people, and we call them mine workers, and you arrange payments for them. But then NRD, what they did, they came and organized people that are living close to the mines and people coming from neighboring towns, gave them small equipments and told them, you go and mine, whatever production you will have, we will buy it at a price, and we will take it to mineral traders in Kigali, and NRD will sell it and retain a profit. So that was not the model. The government was looking for a company like NRD because it was considered as a large investor. We thought it will bring in machinery, plants, structure, and organization that will transform this artisanal way of working into a modern way of doing business. But unfortunately, we ended up seeing that NRD has not that capacity and has not that intention.
Mr. Imena, I have a question in the same context. We have heard from the professional bailiff that he enforced judgments in favor, as I understood it, of employees who hadn't been paid. And I wasn't clear whether those were actual staff that had been hired under contracts of employment in order to do mining work for NRD, or whether those were artisanal miners who had, as it were, sold minerals to NRD for NRD then to sell it on to metal traders in Kigali. I don't know whether that is something you can answer because you're, of course, the minister in Kigali and not on the site, but maybe you can throw light on that.
Thank you very much. The little information I have about it is that NRD had few employees, permanent employees that are paid, I think, on a monthly basis. And those employees would be mostly in charge of accounting, drivers, maybe security people who will be controlling few of the equipment that the company had brought, and other people doing the day-to-day work. And those would maybe constitute 5 or about 5% of the whole workforce. But the main number of the workforce is made by those miners who are paid from their production.
Mr. Imena, was there any connection between the fact that the ministry was, as you said, indulgent and constantly gave short extensions and, as we have said, indulgences to NRD, that if NRD were still in charge, then those artisanal miners would not become illegal miners?
The indulgence was really connected to the fact that initially the ministry was looking for investors. And when we heard that this company was coming from abroad, and according to what they initially told us, we thought they would become a very good investor. So the indulgence continued with that prior perception we had, thinking that let them be given more time, maybe they can improve.
Thank you very much.
You're welcome.
Yes, thank you for your assistance. You're now free to go.
Thank you, sir. Thank you.
Should we take the break now? It might make sense to take the last 15-minute break now.
Okay, we will get the next witness ready, and we're going to open up the breakout rooms right now. Okay, Mr. President, the next witness is waiting. I will go off camera and wait to hear you request him being brought in.
I
Yes.
could raise one point of housekeeping just before we do. It's just in relation to the timetable, Mr. President. By the end of the day, Mr. Cowley will have had approximately 19 and a half hours, and I will have had approximately 18 and a quarter. The procedural order, in fact, allocated 24 hours per side, which notionally means there's over 10 hours between us, and obviously we've only got a 6-hour day tomorrow. And I was going to propose a 6-hour day gets split so that first we catch up on the time that the claimants have had longer. So that's about an hour and a quarter. And thereafter, there's equality of time so that by the end of the day, each side will have had the same amount of time. Now, obviously, the precise numbers could be debated and agreed between the parties, but that would be the principle I would propose.
Mr. Cowley, does that sound satisfactory to you?
I would simply like the opportunity to discuss that with Respondents' Council after today and see if we can present a joint agreed upon allocation tomorrow morning, first thing at housekeeping, or have the tribunal resolve it if we don't. I would just like the opportunity to focus on it instead of my outline while it was being presented.
No, I'm absolutely fine with that. As long as it's not going to be suggested there should be anything other than equality, then I'm completely happy to.
Fine, good. Right, then let us proceed.
Okay, we're bringing the witness in.
Yes. Good evening. Previous witnesses have referred to you as Dr. Michael. Are you happy with that?
Hello?
Can you hear me?
I can hear you, yes.
Yes, well, if I may call you Dr. Michael, would you like to look, please, at the screen where you will see a witness declaration? And if you're happy with that, would you read it aloud to us, please?
I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you very much.
Dr. Michael, could you be shown your first witness statement? And I'm going to ask for FDI to pull up paragraph 7. Thank you. I understand there's a correction to a date you want to make in that paragraph.
Yes, the correction is that I actually I worked for the Rwanda Georgian Land Authority. After that, I worked for the Rwanda Natural Resources Authority for 5 years. That was up to 2016, not 2018. So I guess the correction there is instead of 7 years, should be 5 years. And instead of 2018, should be 2016.
Thank you. Now, if you wait there, Mr. Cowley, who represents the claimants in this arbitration, is going to ask you some questions.
Good afternoon, Dr. Michael.
Good evening.
Good evening. Please bring up C32. Dr. Michael, please take a look at this document. Let me know when you're able to answer a question about it.
Yes, I can.
This is a letter you wrote on July 20, 2009 to the director of the National Land Center in support of NRD's requests for the necessary permit to construct a plant at one of the concessions, correct?
That's correct.
I'd like to focus you on the second sentence of your letter to the National Land Center at that time in describing the relationship of NRD to the Rutsiro mining exploration permit area. You say this is a 4-year permit obtained on November 24, 2006, Such permits are expected to be converted into long-term concessions of 30 years when there is success in defining economic deposits. That's what you wrote at that time, correct?
Yes, I wrote it.
And you wrote that at that time to the National Land Center because you believed it was true, correct?
I believe what was true.
I said you wrote that and you believed it was true when you wrote it, correct?
You mean what I wrote? Yes.
If I could ask that R111 be brought up. And it's a 3-page document, so perhaps you could start opening the second page as well and allow Dr. Michael to see what is in front of him. Dr. Michael, when you feel you recognize the document and are able to answer questions about it, please tell me.
Yes, I recognize it.
You wrote this document, is that correct?
Yes, I did.
And you wrote it when?
20 should be like April 2011. So certainly in the months of April, May 2011. I don't remember exactly the exact date, but it was 2011.
And what was the purpose of this document when you wrote it?
It was to assess the value of the report NRD had presented as a document to apply for short-term licenses and extension of exploration license.
And that's the November 2010 application that NRD submitted?
Yes.
Apologize for 1 second. I just need to fix my computer. It's frozen and I need to use that to see because I have a hard time seeing the documents on the screen. So bear with me for hopefully no more than a minute.
Can you zoom in the document so that the letters are not very small?
Yes, I'm going to ask questions about specific sections and I will have it zoomed in for you when I do. Sticking with the creation of the document generally, you wrote this document about the NRD November 2010 application. What did you do with this document once it was created?
We went through we used the detector to assess the way forward with NRD's application.
I apologize, but I did not quite catch what you said. You said, I did hear you say, we used it. Can I
It
ask
was
you-
used. It was used to progress with NRD's application for this short-term licenses.
Okay, and prior to your preparing this assessment, had anybody else on behalf of Minarea undertaken any review or analysis of that application?
I can't recall. I don't remember.
When you did your assessment, were you working with anyone?
Well, I generated it generally largely myself, but we're an institution. We could always benefit from each other's professional input, but I generally wrote it.
And did you write it for someone else to review and take action on as far as you knew?
Well, because I was in charge of assessing such a report, of course, yes, the minister would refer to it, and so it was a document that could be used by whoever was responsible for dealing with this license application.
And who did you understand that to be in April 2011?
Sorry?
In April 2011, who did you think was responsible for dealing with the NRD license application?
I don't understand your question.
Okay. In answer to a previous question, you said you wrote it for whoever was responsible for dealing with NRD's application. Do I have that right?
I mean, that means assessing and also taking decisions, yes.
And who at that time did you think was going to use this document as part of that responsibility?
No, I believe also our minister was using it to finalize on the way forward with this application.
On the first page, second paragraph, if that could be zoomed in so Dr. Michael could review it. As part of the introduction to your assessment, you wrote, the nature of the agreement was, and just to be specific, I'm going to pause there. The agreement that's referred to in this sentence in your report is the initial exploratory license agreement with NRD, correct?
Yes, this was the 2006 contract and the agreement that accompanied it.
So the nature of that agreement, you said, was one, provide a progress report on the exploration program activities after 2 years, and two, provide resource evaluation reports and the feasibility study after 4 years. Based on this, a long-term mining license would be negotiated. You wrote that, correct?
Yes, I wrote it.
And you wrote that, when you wrote that, you believed that was true, correct?
Yeah, it was true that if the NRD provided both the report and the feasibility study, yes, there would be a possibility, there would be a negotiation for a long-term license, but this would depend on whether we got a satisfactory report from NRD.
If I could ask that on page 3, the top paragraph be zoomed in. Have you been able to review that, sir?
Yes, I can say it.
I want to focus on the second sentence that the preliminary exploration work referred to in the prior sentence you said was crucial in light of the large area given to the company because of its express financial and technical capability. The large area that you characterize or reference that way refer to the 5 mining concessions subject to the initial 2006 license, correct?
Yes, correct.
In addition to those 5 mining concessions, what are the largest mines in Rwanda?
Well, I can't recall now, but certainly NRD had the biggest chunk because it had a total area of about 32,000 hectares.
But in terms of mining concessions, instead of trying to recall who owns them and which ones are jointly owned, other than any of the 5 that NRD was licensed to operate for a period, what are the largest mining concessions that you can identify in Rwanda?
Well, the largest, I don't remember very well the acreage of each one of them, but definitely either Rutsiro or Gatumba were definitely among the biggest. But I can't remember exactly how the variation of the areas of these concessions was then, because they haven't been modified.
How about the most productive mining concessions? Instead of worrying about trying to remember the specific area, what are the most productive mining concessions in Rwanda? Not referring again to the 5 NRD concessions.
Sorry, come again. I didn't understand your question.
Yeah, okay. So there were 5 concessions originally subject to the NRD exploratory license. You've characterized them here. I'm asking about the rest of the mining concessions in Rwanda. What are the most productive mining concessions in Rwanda that you can recall?
You mean today? Do you mean today?
If it changes your answer, you can explain it that mining concessions were more productive back then, but not now. Tell me as you understand it. I don't want to suggest I have an ability to specify the most important time. You know how you need to break it down for the answer. I'm just trying to get a sense of who the comparable concessions are. That's all I'm trying to do.
Well, if I remember in 2010, 2011, 2012, Rutongo was producing more than most of the other concessions.
Any others that you can recall as the largest producers?
Oh, well, I really can't speculate, especially, now I'm retired. It's quite several years when
Yes, thank you for
I was looking at the documents and so on.
Thank you for trying. I appreciate it. If I could ask that the supplemental witness statement be brought up, paragraph 9.1. Focused on, and that's going to be a spillover. It starts on page 3 and goes on to page 4. So as best you can, if you could highlight that. You see in your supplemental witness statement given in this case, you say that NRD's 2010 application for the 5-year licenses were for 5-year licenses, but NRD made no application for long-term licenses until 2013.
Sorry, I think it's not the one which is put up there.
I'm having a difficult time hearing you, and perhaps I'm talking too fast. I think it's best if I just repeat the question.
What you've told me is not what is on the screen.
I apologize. Let me. then it's my reading skills that are at issue, I believe. So I'll try to do a better job this time, sir. Do you see in your witness statement that you say in reference to NRD's 2010 application, it was for 5-year licenses, but that NRD made no application for long-term licenses until 2013?
Sure. That's true. They didn't make any long-term license application till 2013. I guess January 2013.
Thank you. Can I ask that the document R17 be brought up?
Sorry?
They're bringing up a different document for you. It'll take a second. Let me bring it up on my own computer for 1 second, if you bear with me so that I can read it. So this is an 11-page document. They're highlighting the first page of an 11-page document. That's large enough, hopefully, for you to read. Do you recognize what the document is from reading that, or we can scroll through the pages?
Yeah, kind of scroll through the pages so they can see.
FTI, please do that for the witness. And then you let us know if you recognize this document.
At least those first 2 pages, yes.
If you could keep going. Do you recognize what that document is?
Yes, I do.
This is a document you prepared and you talk about in your second witness statement. Is that correct?
Yes.
Now, if I could hold on 1 second, I'll direct to a specific page. When do you say you prepared this document?
Well, it should be March 2015.
Okay.
I
Now,
don't
if could
remember the date, but it should be March 2015.
Thank you. If you could take them to page 7. In section 4 of the document that you created in March 2015, you describe as the application for long-term license the November 29, 2010 application and extensions after expiration of the original short-term license through October 2012. Do you see that?
Sorry, which one is that paragraph what?
Okay, so do you see section 4 of this document is highlighted? It's brought up in larger text. If I could ask that the first paragraph be highlighted in yellow.
Oh.
Have you read that, sir?
Yes.
You'll agree that the description of the 2010 application and the reference to the extension of the license from the original four-year exploratory term through October 2012, you describe in the heading as application for long-term license. And if I could ask that the heading be highlighted in yellow so he understands what that means. Do you see that that's how you characterized it?
Well, I think that was certainly it was not a long-term license, but that was an oversight.
I just wanted to direct your attention to it because my question to you, sir, is you wrote that language. That's not something somebody else wrote for you and you signed off on, but you wrote this memo, correct?
Let me read through again to understand.
I didn't quite hear what he asked.
This definitely was a misrepresentation of the facts on my part. But what they had applied for was actually a 5-year mining license and an exploration license.
I think I understood your answer, but I just wanted to be clear because like the question that I was trying to ask you was, you wrote this document yourself. This isn't just a document that was prepared by someone on your staff, correct?
Yes, I wrote it, yes.
I'm done with this document. Dr. Michael, are you able to identify all the other short-term exploratory license holders that applied for extension?
Sorry?
I apologize. I'm speaking slowly and perhaps I'm making that more confusing. I'm trying to avoid speaking quickly. So I will try again. Are you able to identify the other short-term exploratory license holders who submitted applications for additional license periods, long or short, following the expiration of their normal exploratory term? Do you know who those are?
Well, it's some time back, but Rutongo certainly did apply for the extension or the renewal of the license. I can't remember the others.
Okay, so I'm not going to try and make this a memory test, picking off every name. Can I ask, do you recall approximately the number of short-term exploratory license holders that, following the expiration of that initial 4 or 5 year term, they applied for additional licenses to operate the concession?
Come again?
Do you recall approximately how many there were, sir?
No, I can't speculate now.
Can you recall whether there were any other short-term exploratory license holders from this initial privatization time period in the mid-200s, similar to NRD, who when their short-term license expired, they applied for an additional license, and that as of 2014, that still, a decision still hadn't been made? Were there others?
No, I can't remember when. I can't speculate.
In 2014, did you become familiar with the dispute that arose when Ben Benzingi claimed that he had a right to exercise control of the operations of NRD?
Well, I recall it, but I didn't follow it up closely.
And just to be clear, what do you mean you didn't follow it up? Was something brought to your attention for action?
No.
Did Mr. Benzingi inform you of his position?
I don't remember. I really can't speculate.
So you're saying you don't recall how you heard of it?
No, I recall the dispute, but I don't, certainly I'm not, didn't follow the details of the dispute.
Okay, if you could bear with me for a couple more questions, I wanted to see if there's any aspect of it that you might recall. Do you recall that as part of the dispute between Mr. Benzingi and at least Mr. Marshall, Mr. Benzingi was given the keys and control of the offices of NRD by Bailiff Bosco?
Well, I am not certain about the truth of that, but definitely in some of the documents that Marshall was asked to produce, he indicated that Mr. Benzingi had taken the keys of the office, but it was not in my remit to follow. I guess it was being considered within courts, and
do you have a, I'm sorry, I didn't mean to speak over you. Do you have a recollection that Mr. Benzingi for some period of time was the person operating in charge of the NRD concessions?
Well, yes, partly, he had, it's reported in the record that he had 15% of NRD ownership. So definitely he had access to NRD concessions, but to the extent of how he was involved and the depth of it, no.
Is it accurate to say that Minarena, as a department, is responsible for knowing what individuals are operating and owning the companies to whom mining concession licenses are granted?
Sorry, come again. I didn't understand you.
Was the Ministry of Mines responsible for knowing and keeping informed of what individuals owned and operated companies to whom mining concession licenses had been issued?
Yes, it was, but with NRD, the change of ownership was always initially not very clear, not even clear to the ministry.
Did there come a period of time where you learned that at the NRD license concessions, there was violence among the miners breaking out, and Mr. Benzingi at that time was operating the concession?
No, I can't speculate.
I have no further questions.
I have no re-examination.
No, we have no questions. Thank you very much, Dr. Michael, for your assistance. You're now free to go.
Thank you.
And there's no further business that we can now do, is that right?
Correct, Your Honor.
Right. Yes, well, perhaps council can use the unexpected piece of spare time to discuss what, if any, further procedural orders should be made on close of this hearing tomorrow. I have particularly in mind the question whether there should be post-hearing briefs, and if so, the nature of those briefs. Is that something that has been discussed to date?
Between council, there's been no discussions.
Sorry?
Between council, there have been no discussions on that issue. We could discuss it this afternoon regarding the timing for tomorrow. We typically get a report of the time, current time, shortly after the close of the day from Mr. Kaplan. Once that comes out, we can discuss both issues.
Very well. Mr. Hill, there's nothing else we can do this evening, is there?
No, not from my point of view. Mr. President, you're right. We should, before tomorrow, the party should liaise on whether there should be close hearing briefs and length, because
Yes.
I think where we got to before, I think both parties were agreed there should be close post-hearing briefs, but there was a debate about the length, and that's still a live debate. And then there's also, I hope it won't be contentious, it's just the allocation of tomorrow's hours. That's again.
Yes, I think I don't anticipate we are going to have any problem with timing tomorrow. And could I just say this about the post-hearing briefs? The tribunal would be very grateful if these would focus on the evidence that we've had and how that fits into the respective cases of the parties. What we don't want is a complete rehash of or repetition of pleadings. We would like to focus on the effect of the evidence we've heard. Right, we will adjourn until midday tomorrow.
Thank you.